First of all, I want to welcome everybody who is here. This is Charleston County Bar Association's annual What Works for Me CLE, which is the longest running program and by far the largest program that we have in the continuing education realm, and obviously the most popular given the number of folks who are participating, and I thank you for that. This program may be in some small part due to the proximity to the CLE deadline, or just the fact that we have some wonderful practitioners who are here to share with us over the course of the day their background and experience that has proven effective for them over the years. But I think you'll find that this is going to be a great program. You can download the agenda from the Charleston County Bar Association's website. I provided the URL address in the chat box, so it should be pretty easy to click and get the agenda for today's program. This program has been approved for 6 hours of continuing education. That will include 1 hour of substance abuse and mental health. It also includes 1 hour of ethics. The course approval number for this, if you will write this down, and I apologize if you can hear the dings on my phone. I'm trying to get the information for you with regard to the materials for the presenters. I believe that that can be obtained from the Charleston County Bar Association's website. If you go to the CLE calendar and click on CLE What Works for Me, in that are a couple of click here's, one of which is click here to view course materials, and that will get you, whether it's an outline or PowerPoint slide deck for the presenters, that is available on our website for those who want to follow along. These CLEs are a free service that the Charleston County Bar Association provides to its members in good standing. If anyone has a question or concern whether or not they meet that criteria, please contact Kim Steele, our executive secretary. She can be reached at secretary@charlestoncountybar.org. If anybody who is registered for this and is attending but is not currently a member, you will not be included in the list of attendees that we report to the commission. So please contact Kim Steele if you want to be included and want to get credit for this, so that we can make the arrangements necessary for you to be a member in good standing. Also, if anybody is accessing this program today using a telephone and not, even if you're using your smartphone as a screen, that's fine. But if you're just calling in on your telephone, all we get with regards to the report that we have to file is a telephone number, and that doesn't help us to identify you. So please email Kim Steele at that secretary@charlestoncountybar.org email address, so that we can put a name with that telephone number for purposes of the attendance report. We appreciate the opportunity to continue serving the members of the Charleston County Bar Association during the challenges that this pandemic has caused. The traditional in-person delivery of continuing education obviously has been severely limited over the last year, and with the assistance and flexibility of the Supreme Court and the Commission on CLE, we've worked out an arrangement where we provide these services over Zoom in this webinar function. To date, we have already provided over 36 hours of programming for our members, and we appreciate the opportunity to continue serving and doing what we can, and hope to be able to do more with regards to socials and other community service and the traditional activities that the bar has always performed but has not been able to do over the course of this last year. This CLE has participation requirements. So in order for everyone to meet that interactivity requirement and get credit for this program, there will be 2 polls that pop up on your screen during the course of the program. And we need you to click yes and submit that response in order for you to get credit. And we have to submit a poll response form to the commission so that they know that you are interacting with the program. What I'm going to try and do is do them at a transition point. So I recognize that's also the point where somebody may either go to get a drink or take care of other matters. But if you'll kind of keep an eye on it. I'm going to do one in the morning, one in the afternoon, just to kind of give you an idea. So once one poll has occurred during one of those periods, you'll know that you have a few moments at the other transitions. So just kind of keep that in mind. As I said before, I think we've got a great panel. They're here today to speak on criminal, family, civil, real estate law, also ethics and mental health. And we're going to begin our program with criminal law. And that is being presented by Chris Adams and possibly his law partner, Scott Bischoff. As everybody knows, can happen in the practice of law. Chris got a late notice of a federal court matter in Florence, which caused a conflict with his presentation today. However, we were able to get his presentation recorded in advance. And I'm going to pull that up so that we can observe that presentation. And then hopefully he will be able to connect with us at the end of his presentation in order to answer any questions that anyone might have. So what I'd ask you to do is, if during the course of his presentation you have any questions, if you will go ahead and type those into the Q&A function so that we will know that there are questions and I can let Chris know so that he can log on and answer those. Chris started his career as a public defender after graduating from Georgetown University Law School, has been practicing for over 30 years. He, as I mentioned, he began in the Charleston County Public Defender's Office, where he represented a wide variety of criminal matters, ranging from driving offenses all the way up to capital murder cases. And that's where I first met Chris and got to see, as he developed a high level of advocacy skills when I was on the bench with Judge Danny Pieper. Chris's reputation quickly led to him being named the founder of the founding director of the Georgia Capitol Defender's Office, worked out of Atlanta for a number of years. And during his tenure in that office, he resolved over 40 cases without a single client of his being sentenced to death. Chris now handles private practice matters and all kinds of criminal defense cases, and is currently serving as the National Association of Criminal Defense Lawyers president. So I would ask that you join me in welcoming Chris Adams, and if you will bear with me just a moment while I get his video up, I would appreciate it. Sorry, trying to do too many things at once. Okay, let me share my screen. All right, here we go. Thank you for your patience.
David, thank you so very much for that introduction.
So let's try that again. Hopefully everyone can hear it now. Please let me know if you can't. Sorry, I'm trying to figure this technical. Hmm. I'm very sorry.
Instead of saying like, dude, we're never gonna put around this DNA, I need to say, this DNA looks like.
Okay, let me try this. I
Approach
apologize.
the case as trial. I talk about trial, 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 trial. At some point, a client will say, well, these other people are getting pleas in here. Where's my plea? I go, oh, you want to talk about a plea? Well, let me see what we can do. I thought we were talking about beating this case at trial. It is a little bit of reverse psychology, but it also changes the dynamic of the relationship in a positive way. And I think the clients have much more buy-in when it's their idea on when to initiate the conversation about a plea. There might be a concern as opposed to me pushing it, me being the dump truck trying to push a plea down their throat. There might be a little bit of a concern in some cases that if you don't move quickly, you might miss a golden opportunity to resolve a case. Sometimes that's true, and sometimes I want to have that conversation with the client. Other times that's not so true. I got into a case late, about a year ago, a federal drug conspiracy case. And the prosecutor was saying, listen, I've got everybody lined up. They're sort of all gonna get cooperation credit against your guy. You know, your guy can come in like immediately and maybe you can get ahead of this thing. And I said, yeah, I completely understand where you're coming from. But let me tell you what I learned. I've got to talk to my guy about trial. He, because 95% of the cases or more plea, we're likely going to plea, but for this to work, I need for this to be his idea. So I need a few weeks so I can have multiple conversations with him, and then we may very well follow back up, but please do me the courtesy of leaving that door open for a little bit so that I can earn the trust that I need to try to get to the right result, if that's the right result. And the prosecutor paused, 1,000, 2, 1,000, 3, 1,000. Oh, that makes sense. Okay, well, I'll check in a month. And we were able to negotiate that case out in a good way. So talk about trial, let the client initiate the plea talk. Don't be the dump truck. Some of these 10 tips are about clients, and some are also about working with prosecutors and judges, and a few are mindset and attitude. This is about clients and mindset and attitude. As a young public defender, we felt overwhelmed with our caseload. We were overwhelmed with our caseload, but I knew nothing else. So it was my only existence. So I didn't know if other lawyers were quite as insane as we were. But I would race up to the jail, usually late, would have about 45 minutes, and I'd have 14 files. And I didn't need to do stuff with everybody, but I needed to touch everybody for a minute. And the jail, for those of you who've been, is never, ever been that efficient. That's not a Charleston County detention center issue. That is a universal issue at detention centers. And I've been to them from, I guess now, Vegas to Brooklyn to the Virgin Islands, and they're inefficient everywhere you go. We have to just chill out. We have to go there with the idea that less is more. I'm never going to see 14 people in a morning. I need to just be with the ones I'm with. Love the one you're with, and go in and listen to them. Put my agenda aside and really listen, and listen some more, and listen some more. And then when they're done sharing whatever they need to share, then it's time for me to say, so I need to get some information from you about the bond hearing, or let me tell you how the preliminary hearing went, or here's the discovery, let's start going through it. But we, as the control people who want to fix everything, have a tendency to want to race to the conclusion. And so much about being a good lawyer for people is their perception of you caring for them. And nothing shows that you care for them more than really, really, really listening to them and being in the moment with them and empathizing with their situation. So kick back like you're on a front porch in a rocking chair with your beverage of choice, lemonade, bourbon, whatever your thing is, and just relax with that client in the time you have together. For some of you with significant caseloads, if you have public, tell you is 5 quality minutes with a client is better than 1 minute and then trying to hustle them out the door and spending 5 minutes arguing with them about whether you care about their case or not. So I think it is time efficient to sort of just be in the moment. Keep all of our promises. Keep all of our promises. That's not really what I want to share with you on this one. I want to share with you, why are you making promises that you can't keep? We all do this. I do this. I did this yesterday. And as I was working on this PowerPoint, and I'm ashamed of myself. I haven't learned better, but I'm trying. I'm a work in progress. Dr. Tony Amador is a psychologist who is specialized in working with paranoid schizophrenics. And he has done a lot of work with capital defense lawyers in how they can work constructively with paranoid schizophrenics. And what I've learned is either all my clients are paranoid schizophrenics, or these methods that he taught us work in all cases. I think there's a little bit of truth to both. I do think a number of our clients in the criminal court system, especially recidivists, have undiagnosed mental health issues, diagnosed mental health issues, and or severe trauma histories. And I think we've got to be on that from early on in the case. But Dr. Tony Amador says, if you make a promise, you must keep it with a paranoid schizophrenic. And so much of being a good defense lawyer, a good criminal defense lawyer, is earning the trust of people who are in a vulnerable place in their life. We do this by keeping every promise. Tony Amador's second point is, don't make promises. So if you're going to say, I will be there Thursday afternoon to see you, you have to be there Thursday afternoon. If you have a wreck on your way to the jail, that's not enough. That's an excuse. So you have to, if you are not 100% certain that you're going to be able to keep a promise, don't make the promise. If the client says, well, when can you come by and do this for me? Say, I'm trying very hard to get this done. My goal is to have it done Thursday, unless something unforeseen happens. As soon as I get it done, I'm going to call your mother and let her know, and I'll send you a copy over to the jail. Just that little bit of ratcheting it down can go a long way when things do happen that are unexpected. The next point, choose to believe. Choose to believe. This is a little bit like the old folk song of whose side are you standing on? I'm standing on the Lord's side. Tell me, whose side are you standing on? I think a lot of times we get into issues with clients when they believe we're judging them. And they believe we're judging them when they come in and say stuff like, you know, well, these weren't my pants. These were so-and-so's, you know, my brother's pants, and they had a quarter bag in them and it wasn't mine. And we say, why are you wearing your brother's pants? That's crazy. Nobody's going to believe that. And we have to check ourselves, because we're trying to help, but we have to make sure it comes across in a way where we're trying to help. So I think it's been helpful for me to share with clients that, listen, because sometimes clients will say, it sounds like you don't believe me. You're not fighting for me. And I try to say, and this happened in a drug conspiracy case that we had with Judge Gergel 2 years ago, where he said, listen, we are fighting like mad to help you. And we choose to believe you. We have a choice. You hired us. We choose to believe your version of events. We're working hard to make sure that version of events is the one that is ultimately going to be believed in court. This thing, this wiretap statement, these pieces of physical evidence that we're working on today, those are going to be hard for us to convince jurors to believe your story. But we choose to believe you. It's our free choice. The prosecuting agent, the prosecutor, they choose not to believe you. They choose to believe that you're a major drug dealer. We choose, because you're telling us that's not true, we choose to believe that you're innocent completely of these charges. So let's get together and work on this problem here. Sometimes I've run into prosecutors who've said, Adams, you can't possibly believe that. And I'll say, you know what? I choose to believe it. I mean, I could be cynical and reject it, but in this beautiful adversarial system of ours, somebody needs to believe the defendant's statement and see if it can't hold water, as they say in My Cousin Vinny. And I'm happy that that's me. So do you have some evidence which punches a hole in this theory that we're working on? And you know, they look at you like you're crazy, but then they end up going back and trying to get you the information that you need to keep trying to work through the problems. So make sure you're clear, you choose to believe your client, and make sure they know that you're approaching the problems with them and from their perspective. All right, this is a fun one. And I've got a few, let me get my little notes out. I've got a few things to say about this. Be righteous. Be righteous. Don't be self-righteous. Don't be a jerk. So I identify as something called a true believer criminal defense lawyer. I don't know exactly what that means, and you may have an idea of what that means. It's a little bit different than mine, but I watched a movie, True Believer, in the 90s with James Woods, and maybe some of you did, but I like to approach being a defense lawyer from a radical perspective that the government gets it wrong a lot of the time, and that they're trying to hurt people, and it's my job to fight them. And I want to be righteous and empowered in being that person for my client. But what I've learned along the path is sometimes my quest to be righteous gets interpreted as being self-righteous, which is never beneficial to my client, or being a jerk. There was a lawyer, I went to a courtroom with this I'll say it now, he's out of office, a really horrible DA outside of Atlanta who had more people on George's death row than anybody else. And I had a hearing with him, and we went in the courtroom, and there was another lawyer in there who had represented this guy in the first trial and had never been relieved from the case. And he was a well-known Atlanta kind of drug lawyer from the 80s. And he had a ponytail, which I'm just telling you so you can picture it. I'm not criticizing that, as people like David Wolf might remember my hair choice from back in the day. But we came in, and you know, I did what I usually do. I get to court a little early to eliminate stress and to get sort of centered in my place. And I saw this prosecutor who I had to deal with a little bit in cases, as well as at the Georgia legislature at that time. And so I went over and I said, hello, hello, how are you? He said, fine, how are you? I said, good. And then I went and sat down and waited for my client to come in. And this other lawyer wouldn't speak to the DA at all, or the assistant DA, or the judge's clerk, or anyone else. And I believe his perspective was that he was being a true believer defense lawyer, that this was an illegitimate system, and he was not going to speak to these bad people. I think that is short-sighted. I think that we need to be able to work across the aisle if this system is going to work better. If we think there are problems in the system doesn't get any better by me throwing eggs at the prosecutor or their house or anything else. The system gets better by me talking and engaging and seeing in the places where we can find common ground. So if you view yourself as a true believer, make sure you keep lines of communication open. The other thing is, when your client is in the courtroom and you're going to go up and talk with the opposing counsel, make sure you tell your client what you're doing, because most clients are very suspicious that you're going to sell them out. And it's just really helpful to go, hey, David, over there's your prosecutor. I'm going to go grab some paperwork, and then I'm going to talk to him a little bit, maybe about football, maybe a joke or whatever. See if he's in a good mood, maybe see if we can't sweeten this deal up a little bit, okay? So if he smiles at anything, maybe, maybe I'll be able to come back with good news for you. So just let the client in on what you're going to do. So a lot of times they see, oh, there's the lawyer club. I don't know what they're all laughing about. My life's on the line here. So make it a strategic issue with your client. The thing that I like to do in court, especially for juries, is I like to think of myself not as a dueling lawyer, but I like to think of myself in some silly way as kind of a Boy Scout for justice. And I never made it past Webelos, so I don't really know what I'm talking about, but I want to present as somebody who is concerned about the outrage of charging an innocent person, who is going to do everything in their power to object and fight the government, witness by witness, piece of evidence by piece of evidence, in an appropriate professional way. I don't want to do things that turn it into some sort of silly lawyer game of gotcha. And I think we do that. When I was in the public defender's office, we had a prosecutor who had an Italian name that I tried a bunch of cases with, and tried a bunch of cases with many of us in the office, because he did not plea very many with good plea offers. And so we were in trial a lot with this gentleman who is a friend of mine. And somebody in our office, also of Italian descent, loved to call him the wrong name. He would mispronounce his name, and then the judge would mispronounce his name. And then we would come down in the breaks from the trial, and all of us PDs would be giggling about everybody calling the prosecutor by the wrong name. And the prosecutor, for his part, would jump up and object to his name being mispronounced. And it was silliness, right? And everyone in my office thought this was great and hilarious. And I couldn't quite figure out, it didn't seem funny to me then. And the more I thought about it, and the more I sort of, I hope, grew, the more I realized what I didn't like about it. What I didn't like is that's about lawyers. That's a battle of lawyers. Who's clever? Who's funny? Who can kind of one up? Who can change the chair so the prosecutor sits in the short chair for that morning in court, and then you see him playing with the chair. We're on something much more important. We're on a quest for justice. It's something, you know, that we should be so proud of, that we don't have any time for the silliness that we get into when we're thinking about it as lawyers' games. So stay on the crusade for justice, stay with your sense of righteousness, be a Boy Scout or Girl Scout for justice, channel that in a way that helps protect our clients. Litigate, don't capitulate. For any of you who saw The Man Who Wasn't There from the Coen brothers, you may remember this. The Man Who Wasn't There was Billy Bob Thornton, and it was a black and white movie. So I think it was in the 30s or 40s. And he was in Petaluma, California, I think, north of San Francisco, beyond suburbia. And his wife, Frances McDormand, who I've always loved, was having an affair with her boss at the store, the Belks of Petaluma. And Billy Bob, who was a barber, found out, and the guy ended up murdered. And it was about his murder case, this movie, and about who this man was and his psyche. And they go off to San Francisco and hire the famous criminal defense lawyer in San Francisco, who was Shalhoub from Monk, Tony Shalhoub. And he came in and he was hilarious as kind of the big city lawyer. He took over a suite at the hotel. He did everything. He was, you know, he was very persnickety in his way. And there was a scene where McDormand, the wife, and Billy Bob, the husband, were trying to tell the story to the lawyer in a way that might work for the defense. And Shalhoub kept shutting him down and said, "Oh, you can't tell me that. You can't tell me that. That's not going to let me do this defense. Now I'm not going to be able to do this defense. Oh, they think I have us. They think they have us. But you didn't hire me to come in here to just plea your case. I litigate. I don't capitulate." It was a great scene in the movie. The scene was much less than my recounting of it. Litigate, don't capitulate doesn't mean litigate every single issue, but it means work really hard. We work hard for our clients. That's a good thing. Keep working hard, work harder. We whine. I whine. I have whined for 28 years as a criminal defense lawyer. I complain and I moan and I pull the prosecutors aside and I give them an earful and I do this. I don't know why I do that. The reality is I should whine less and draft motions more. Whether it's COVID and the closure of courtrooms and the reopening of courtrooms, we complain about things. Very few times does that turn into motions where we're litigating issues. My 2 cents worth today is, I think I have a great friend who's a longtime chief litigator at the public defenders in Colorado. And he said, be a go boy, not a no boy. And he said, you just need somebody on the team who's going to tell me how we can do something, tell me how to do something and do it, rather than just complain and give me all the reasons why it won't work. We need to tell ourselves that. We need to be go boys and not no boys. If there's an issue, instead of whining, let's write a motion that we can actually tee it up in front of the court for the court to rule. The court can rule against us. I can tell you, they rule against me almost all the time. But we've got to tee up motions because they'll never be able to rule for us if we don't present a legal issue. The other thing is sometimes we don't present legal issues because truthfully, we get trapped by the systems in which we work. And that's understandable. And I've done the same thing. We come out of law school, we're trying to learn the language. The first probation revocation hearing that I had, I was trying to remember if I said terminate or revocate. And I was practicing, I could barely get any air out of my throat to make the sound. And I was so afraid I was going to flip the terms that I was going to ask for prison when I really wanted the case to end. We work hard to learn the language of court so that we can appear more competent maybe than we really feel deep down. That's okay. We have to learn the rules and the language because that's how we help and protect our clients. Once we learn that, never forget about the sandbox. Remember that sandbox when you were 4, 5, 6 years old, and the issue was, but that's not fair. That's not fair. You know, Johnny's playing with my truck, Mom, and won't give it back. That's not fair. I think part of us to be a successful criminal defense lawyer, we need to remember our little kid who was in that sandbox. And if there are issues that just don't seem fair, it doesn't really matter if there's a rule against it or not a rule. Something like COVID court reopenings, there might not be any case law against litigating that. But maybe there are some issues with rules against litigating, perhaps a repeat bond hearing request where you're denied because you've already had one. You know, maybe you just need to litigate that. Maybe you just need to say, here's why. We have a written motion requesting a second because we have a second change of circumstance that we think's sufficient, or we want to litigate that we can't reopen court because of this, and we would like for expert funds from the state to be able to get experts that can come in and help the court make the right decision here. The other part of this litigate, don't capitulate. I was told a lot early on about don't tilt at windmills. And I would get this some from the prosecutors and some from the judges. We had a senior judge who was around all the time back in the 90s. And I had a number of cases set for trial in front of him, Judge Luke Brown, who was a very nice man, very practical. But we would go in and pre-screen the cases before him. And sometimes he would jump in and help us resolve them. He'd make the state give you a couple more years off or whatever so you get the plea done. But we'd go in and he'd say, well, is this case ready for trial? And I would say, well, Judge, we have this little issue with the Brady material that I'm still waiting on. I requested, you know, this and this and this, and I don't have it. And I remember one time he said, now, Mr. Adams, you're always tilting at windmills. I can't remember a time where you've ever come in and said you had all the Brady material. And I responded to him, I said, Judge Brown, thank you. And there was a little pause, and then he laughed. And I said, well, Judge, if they're, you know, when they give it to me, oftentimes we're able to resolve cases and matters and they don't come to you. But when they don't give it to me, it seems to me that you're the appropriate forum to resolve the issues. And, you know, I think this issue of our credibility with the court is somehow being in the court's good graces. And I think the court values people who litigate, who think through their issues, who are filing motions, who might be pushing the system for a little more fairness maybe than other people get. I think we earn our credibility by doing our very best for every single client. And I know there's some people who good friends of mine who will say, well, I don't do sentencing memos in every case, because if I do them in every case, the judge will tune out the ones that have less, they'll tune out all of them because I'm filing these in the ones that have less merit. And my response to that is, well, gosh, that makes a whole lot of sense for the people that we believe have more merit. But what about our poor clients who we think have less merit? Don't they actually need more advocacy on their behalf, not less? I mean, I would hate to be the client who's represented by a lawyer who says, you know what, with people with good sentencing cases, I'd file this. But for you, schlep, let's just see what we can get. Maybe the judge will have had a good night's sleep and be doing it, feeling pretty good. Maybe we can hold off and get a gift. No, I would want my lawyer working and doing his best for me, like I would hope he would do for every single case. So I would say that our credibility is tied up in our level of commitment and our ability to produce work product much more than it is about picking and choosing battles, which I think is a term we often hear. Let me go back. It's another thing about our credibility. One thing I've learned, I've done a little bit with storytelling, and it's not a hobby, it's an avocation of mine as part of trying to learn more about litigation. What I've learned in storytelling through the study of it really is consistent with this notion of our credibility is earned by doing the best we can for each and every client, rather than picking and choosing. Aristotle's classical rhetoric triangle was the way for millennium that people were taught how to persuade with rhetoric. And I think, and this is a copy of the triangle, there's ethos, credibility at the top of the triangle. It's not at the top because it's more important. They're all of equal weight. Logos is logic and consistency. I'm not going to talk to you about that because that's what law school did for us for 3 years. They tried to force us to be more logical than we wanted to be. Ethos or credibility, I think sometimes we become too obsessed about that, about how do I appear? How do I appear in front of the judge rather than how does my client appear? The pathos is the emotion and imagination. In others, if you go online and search Aristotle's rhetoric triangle, others would come up with pathos equals emotion and story. What I believe, what I try to practice is that learning the stories is what builds the emotion in the case. And that's true for sentencing, that's true for bond hearings, that's true for trials. The logic fits with that, and together those things combine to give us credibility. So if I go in and I'm complaining or whining to Judge Luke Brown, I may not have any credibility because I complain and whine all the time. But if I go in with a filed motion and I explain to him that this is the reason why we need those records that are in the possession of this agency. I understand the solicitor does not have them in their file, but we think that under Brady and Kiles versus Whitley, they have to go get this information for us because it's critical to our preparation of the defense strategy. Those records, we believe, will show that these people had 4 phone calls with each other before, and that would show that this was a matter of consent and blah, 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 blah. Whatever the case is, if we can tell it, package it together in a little story. The night before, they were out in a bar, there were 3 people, they saw them texting. We found one of the witnesses, the other 2 are gone. To corroborate that critically important witness, we need these records so that we can achieve a just result in this trial. If we're able to put in a little story nugget that is logical, then our request has credibility and the court trusts us and they do what we asked, or jurors trust us and they do what we're asking of them. So think about how we get stories into the mix, which is a full topic on its own. And it's I think, critical to persuasion, and would be happy to do, I do a talk on that that's a full hour, so I don't want to go much longer there. Next, as we're sort of have about 10 minutes and a few to get through. So be a problem solver. I try to approach, now that I'm a little bit older, Sun Tzu, The Art of War, talked about the young warriors going in and going to battle, and somebody would come out dead and bludgeoned, and there'd be a winner and a loser. And Sun Tzu talked about when you grow a little bit, you can become a warrior who can win a battle without ever having to fight. And I think part of my evolution, is I want to present myself as a problem solver to the court. I am, my disclosure, my personality, I learned early on that I'm really a win-win negotiator. I would hear some lawyers who would give seminars, and they clearly were win-lose negotiators, and they would talk about doing this or doing that, or being really nice to all the bailiffs so that when the jurors were there, they could see that you had this relationship with the bailiffs and they would like you more. So it was about being kind of a puppet master that manipulated the scene to get the best result for the client, one where they won and the opponent lost. That didn't really work for me. I'm a win-win person. I want to like the bailiffs because I would rather like the people that I see frequently than to not like them. It's just easier. It's human. I want to be open and available. I don't want to be a condescending lawyer. I want to have friends. I prefer to have friends as opposed to not having friends. But I want them to be real relationships. And I want that to occur also with opposing counsel, because I think if I treat them as somebody I have to beat to get a plea, then I'm inviting problems. But if I treat them as, here's the issue with my client's criminal history and the facts of the case, the underlying root problem was trauma, or the underlying root problem was drug addiction, which was self-medicating for this traumatic childhood or whatever. We now have her in a treatment program. She's doing great. She's sober. She's done this. She has a job for the first time. It would be wonderful if you could give a little bit on this so that we possibly could keep her on this path of rehabilitation. I have found that a lot of times when I am honest and treat the opposing party with the courtesy of that they might be open to doing something in this matter, that a lot of times they'll do it. When you appeal to somebody's better angels, they might actually sing for you. And that's not, in my view, that's not manipulation. That is collaboration with another lawyer to try to keep somebody from coming back and creating problems in the future. I also went through a little phase, I'll toss this in, of radical honesty, where I thought that was the way to be as a lawyer. And I had a death penalty case in Floyd County, Georgia, which is where this QAnon congresswoman now lives, from Georgia. And my prosecutor was sort of a tough prosecutor, and we had a bit of a cantankerous relationship. And I had this idea on how to resolve the case one day when my client was willing to plead to not have the death penalty. And so I drove up and I said, I want to meet with you just to talk. And she said, Allah, can you tell me? So she didn't trust me. And I went in and I tried to be radically honest and to be a win-win person. And I tried to just say exactly what we needed to resolve the case. And I tried this with a few other prosecutors at that time, like, here's what we need, we can move this case. And she, first of all, wouldn't meet with me one-on-one. She had two other witnesses present, which was interesting. I explained to her how I thought this was a no-brainer to resolve, that I didn't think they'd ever get the death penalty against my guy. I didn't think we would ever beat the murder charge. So we would likely end up at this place. Why don't we just do that with plea without any cooperation, whatever? It just seems like that would be the way to go. Then there would be no appeal and real closure for the victims. she said nothing. And so she would say, thank you for coming up. That was about it. I left. 18 months later, I think we'd had 10 full days of pretrial motions. And she said, okay, I'll make you this offer. So we got to the same spot. I didn't have the credibility with her 18 months sooner to be able to pull it off in a way that would have eliminated a lot of stress for my client. Maybe if I had the next case with her, I would. But the thing that I learned is you probably don't want to put your best and final offer on the table until you're at least close. You have to leave a little bit, even as honest as you want to be with opposing counsel and as much of a win-win person as you want to try to be, you still have to have a little room to give at the end for these things to come together. The last part about being a problem solver is a lot of times the problem we're going to solve, we have to set up the solution from day one. So I'm a big believer that because 98% of the cases end up not going to trial in all across America, and that's true here and that's true in federal court, we have to set up the sentencing from day one. So I don't care if you have an alibi defense or if you have a self-defense or whatever, and you're going to be working really, really, really hard on that. You also can never lose sight of the fact that if you're a betting person, you would bet on this case ending up in a sentencing hearing one day. The best sentencing evidence is evidence that occurs after the incident, after the date of arrest. A lot of times our clients have a lot of problems in life. We have to think early on about what programs can we get them in, where can they go to start really doing the hard work of addressing their problems. Even in Casablanca, you know, at the end, they said, Rick says to the constable, you know, you're not going to arrest me. And he said, no. And the other officers race up and he said, arrest the usual suspects. A lot of times I represent the usual suspects. So even if they're innocent of the crime charged or the government can't prove it, there are other issues in their life that they really could use help on. We've got to help them with that. I represented a woman recently in federal court, and I wrote about her in the criminal defense lawyer magazine, The Champion. So I'll tell you a little more about it than I would ordinarily because she authorized it. She had been a junkie since her brother died in a car wreck when she was 16. And so for 10 years, she was addicted to heroin and crack and was involved in a relationship with various drug dealers. And she had a really, really, really tough, hard life. We were finally able to get her out on bond. We could not get her into drug court initially. We were able to get her out on bond and get her into a treatment house in Greenville. She was doing great there. She had a job. Ultimately, we were able to get her into, with the blessing of several judges and the prosecutor, we were able to get her into drug court ultimately. And her life change has been phenomenal. She's working, she's pregnant, she's in a healthy, seems to be a very healthy relationship. She's been clean now for 2 or 3 years. She's all involved in hosting NA conventions around where she's like at the front table, giving out packets and welcoming. She's a greeter. I could not be more proud of the work this woman has done. All of it was post-sentencing. It was very easy to say, Judge, here we are. The guidelines are calling for a sentence of imprisonment. That would really undercut all the efforts she's made to reclaim her life and to find dignity in her life, dignity that she'd lost since she was 15 years old. To sentence her even to 3 months in prison could destroy everything that she's done that makes us all so proud. And of course, I didn't have to convince the judge. The fact that she had made such a foundational change in her life was what was necessary to get the result. And she is now out doing great on probation. That was all stuff that we started working with her early on. She did the work. I couldn't do the work for her, but she did the work and I couldn't be prouder. Number 8, go to trial, go to trial. and go to trial with stories for persuasion, but go to trial. Trials are dropping all around America. In federal courts, I think it was 1990, there were 22 trials a year for federal judges. They're now down to 4 trials a year for federal judges. They're not working any less. These are hardworking human beings. It's just the number of trials have declined significantly. They're declining in state court. Our population's gone up, but we don't have more trials than we had 30 years ago. We, as criminal defense lawyers, view ourselves as trial lawyers, but the reality is we don't try very many. When we get a chance to try a case, try it, celebrate the client, thank the client, properly advise the client so they're fully aware of the possible ramifications, but we should be happy that we try cases. I hear lawyers say, but when I'm in trial, I lose money, or they didn't pay enough for this much work or this much time. Well, that may be true in individual cases, but if you look at your career as a 30-year career, I can tell you trials are differentiators. Trials are differentiators. People will hire lawyers who are good trial lawyers. You don't have to be Jerry Spence. You don't have to be the greatest trial lawyer in the history of South Carolina. You have to be willing to try cases and to do it enough that you've learned basic competency in the courtroom. It is an art form and a science that we have to keep working on through the years. But if you have developed competency as a trial lawyer, work will always find you. That's just the reality of it. A trial, even a pro bono trial, which I know a couple of years ago, I did 2 of them in a year. I was exhausted. They get paid back in spades from a business perspective. I can tell you that. If you're a young lawyer, this is the time to try cases. You'll be able to get away with things that you just can't get away with if you wake up at 45 and decide to go try a case for the first time. If you're a young lawyer, lean into it, do your best. I've had the honor of training lawyers at NCDC, and also I ran a capital defense office, and I've learned something through the years. I thought everybody was wired like me, and they're just not. There are people who are writers, and there are people who are talkers. And writers they're sort of perfectionist, and talkers are not. And they each have their own set of issues. If you take the script away from the writers, they start to melt down. Not all, but I'm telling you from training, I did this poor woman was doing a workshop, and I took her notes away, and I thought she was going to punch me. I mean, she was very uncertain about that. Talkers never want to do the hard work of writing stuff out. And why it is so important is because so much of the things that work really great in the courtroom are the little turns of phrases that connect different areas of cross-examination or the labeling. It's all the little sinewy tissue, not the big bullet point muscles, but the little things that connect, that when it looks easy, you're in control of the courtroom. When it's not easy, you're flummoxing. In my view, we have to write everything out, and then that word for word, and then that liberates us to be away from the notes. And that was a process that I had to come through, and I encourage you. And for those of you who are going into your first or your second trial, and you're a writer and you're a perfectionist, you're not going to be perfect. No trial is perfect. There's smart people on the other side who are looking to do harm to your case. They will have some success too. They'll focus on things you weren't focusing on. It's not going to be perfect, but trust your hard work. Trust that you care so much about your client. It's going to be okay. Take it easy on yourself. For those of you who are speakers for justice and not writers for justice, up your game. Write it all out. Take the painful time to script it all out, and then you can be really free. And I think it's wonderful. And this last part about going to trial is there's no time that we learn more than when we're really up against it, trying to be our best. And as lifelong learners, it's awesome. Prepping for trial is the worst thing in the world. Being in trial can be a good thing or a bad thing. immediately after a trial, when you've done your very best, it is an incredibly satisfying experience. Help the PCR lawyer. I'm out of time, so I'll just say, PCR lawyers aren't the enemy. I make mistakes. None of us are perfect. If I ever miss on a winning appellate issue that would have a reversal and I didn't object, it's never because I made a strategic choice. It's because I missed it. I don't think it's that hard for us to admit that and then let the courts figure it out. If there was a clear reversible error, I would have jumped on it at the time and either had a ruling for me or against me. But I wouldn't have thought, wow, I'll outsmart everybody. I'm going to let reversible error go through in the case. So reach out to PCR counsel. We have a continuing duty to our client to assist, not to lie, but to assist. Reach out, let them know you're available to give them your file and talk through any issues, and then just be honest. Be joyful. Here's where I want to end. This is the better life part as we sum up. We as criminal defense lawyers are not the highest paid attorneys. Our PI friends make a lot more money than us. Our work's challenging, difficult, and really, really stressful. But on our best days, we protect citizens, we protect people without power from the government. Stand on the shoulders of giants who came before us, from John Adams to Abe Lincoln, Clarence Darrow, Johnny Cochran. Locally, the shoulders of Dale Cobb and Andy Savage. Historically, the shoulders of Cicero. We stand as the barrier between government overreach and our clients. If you can figure out how to live within your budget, you can have a very, very, very rich life representing people in the criminal courts. I stumbled into it as an early lawyer. I wanted to be a trial lawyer and felt really, really fortunate that I found my way into the public defender's office, which seemed to be a perfect fit for me. We make a huge difference in the lives of human beings. If you're religious at all, we kind of feel like there's a little part of the Sermon on the Mount that's written just for us, because we're in there reaching and being with our people, human beings, at their most vulnerable moment while in the jails. And there's something really special about that. And we play an incredible role for our society. If our rule of law experiment is going to continue on, we have to have a vigorous defense bar together and committed to keeping this, to make this system the best it can be. It's a real joy and honor to be with you all today. And I hope you got something out of this, and I would love to see you in the courts. Thank you.
All right, so hopefully Chris is on. So if anybody has any questions for him, we'll do a quick question and answer. And I apologize again for the snafu with the sound. I'm glad we were able to get it up fairly quickly. But anybody have any questions for Chris on criminal law? Okay, well, if not, Chris, thank you very much for your presentation and your time today. We really appreciate it. And I will turn it over to Mary Lee for the second presentation.
Thank you, David. And I just wanted to remind everybody that the course code number is 214-180-ADO. And it will also go out in an email tomorrow that you will get from the Zoom presentation. Next, we have Mary Louise Ramsdale and Margie Pizarro to speak on the temporary hearing. Margie is a native of Walterboro, South Carolina, and she received a Bachelor of Arts degree from Clemson University in 1991 and a Master of Education in Divergent Learning from Columbia College in 2002. Margie spent 12 years as an educator in the Greenville County School District before enrolling at the Charleston School of Law, where she received her Juris Doctorate in 2007. In September 2008, Margie took a giant leap of faith and formed the Pizarro Law Firm located in historic downtown Somerville. The Pizarro Law Firm is a general litigation firm focusing on matters including family law, criminal defense, personal injury, estate law, and medical malpractice. Since opening its doors, Margie has represented clients in all state and federal courts, and she has worked hard to help them navigate their legal issues. Margie's practice has also taken her to California, where she has supported the litigation in celebrity and high asset family court cases. Mary Louise Ramsdale is a principal lawyer of Ramsdale Law and practices solely in family law. She is a cum laude graduate of Harvard Law School, past president of the South Carolina Bar Foundation, and chairs the Charleston County Bar Wellness Committee. She volunteers for fee dispute resolution and was a volunteer attorney coach for the Moultrie Middle School mock trial team. She took the team to first place in the state competition in 2016. She presently coaches the Wando High School mock trial team. In her free time, she is an avid power yoga student and likes to read mystery novels and walk her Portuguese water dog. Please welcome Mary Louise and Margie.
Thank you, Mary Lee. Can you hear us okay?
We can.
Okay. So Margie and I are glad to be teaming up again. We were actually resolving a temporary hearing late into last evening. If you don't practice in family court, temporary hearings are absolutely critical. They are, although they don't have precedential value for a trial, an award of custody at a temporary hearing, an award of support, an award of a home can completely change the trajectory of a case. So in my firm, and I know in Margie's firm, we prepare for temporary hearings like we are preparing for trial, essentially. One thing I'd like to say just up front, though, is think, do you need a temporary hearing? Because every single case doesn't need a temporary hearing. So you don't necessarily need to file a temporary hearing request when you file a complaint. Also, if you do need a temporary hearing, do you need it on every single issue? These are decisions I make on a case-by-case basis. But if I think I'm going to be able to work with opposing counsel, get us into mediation relatively quickly, I often don't request a temporary hearing. They can be quite costly, especially ones that involve multiple affidavits, longer than a 15-minute hearing. There are a large number of documents, which we'll go over, required to do a temporary hearing properly. And they should be prepared literally like you're writing a Supreme Court brief. They are that important. And so with that, I will turn it over to Margie so she can, and I'll go to our first slide.
Okay, thank you all for bearing with us yet again. ML is absolutely right. We just finished resolving a temporary hearing that's scheduled for Monday at 3 o'clock. It's so important to be able to look at the facts of your case and determine, where you can find some common ground and where you can also try to resolve a lot of issues. So not only have we been able to put the parties in a good position, we've also saved them money because now they don't have to pay us to prepare all these countless documents that we're going to discuss. And we've also, which is the most important thing, we've done something that's in the best interest of the children and these parties. So while temporary relief is still very important, if you ever get in a position where you can try to resolve some of the issues, by all means, try to do it. So what is temporary relief? Temporary relief is just that. It is relief that you are asking the court for that is going to be on a temporary basis. From the time that you filed that summons and complaint, you have tons of requests for relief. You have requests as it relates to custody, visitation, who's going to occupy the marital home, who's going to drive what car, and who's going to pay the insurance, who's going to pay, what credit card debt. When these parties file, certainly they want to look to the future. You ask for a life insurance policy to ensure one of the parties' obligation to pay child support or temporary or alimony. So you ask for everything that you want, everything that you could possibly imagine with a good faith basis in your complaint. But when you ask the court for temporary relief, you're saying, we've asked for everything, including the kitchen sink in our complaint, but we believe that it's important that our client has this particular relief at this point in time. Temporary relief, custody of the children, what's going to be in the best interest of the children in terms of who they live with, who's the primary parent, what the visitation schedule is. That's something that you ask for temporarily. As it relates to alimony and spousal support, how is it that one of these parties is going to be able to maintain the same standard of living that they had during the course of the marriage on a temporary basis? You're asking for that. Use and possession of the marital home. Who's going to be able to stay at the home? And again, who's going to pay for that? You're asking for those things on a temporary basis. Now, as ML said, sometimes you may not need temporary relief. If the parties have gotten into a position where they have developed a level of comfort, if one party has already exited the marital residence, you certainly don't need to ask for that on a temporary basis. If the parties have already determined, hey, this is what we're going to do as it relates to custody or visitation, you don't need to ask for that on a temporary basis. Attorney's fees, unless one of the parties is in a position where they're just unable to, adequately participate in the litigation, and prosecute their claims, ask for attorney's fees on a temporary basis, but if not, then you don't have to. So the temporary relief is kind of like a Band-Aid. It's what's going to get the parties through until you've got a guardian ad litem involved, if it's an issue dealing with custody, until you actually have gone to mediation, and had a mediator look at, go through actually all the causes of action to determine where you can reach some type of agreement. So you're going to need it for a temporary basis for those temporary issues. But again, if you don't, if it ain't broke, don't fix it. If the parties are able to, again, maintain their lives and go forward, if they have reached certain agreements. And I think it's always important to, even if they have reached agreements, so that you don't think that you need a temporary hearing, get it in writing. Get it in writing, put it in the form of a consent order, just to ensure that the parties know exactly where they stand. Now, what is the difference between the temporary relief and the relief that you could regret from a motion, from a Rule 6D motion? Of course, temporary hearings, the time for service is certainly shorter. It's 5 days, 5 business days. So sometimes we get caught up on that because we count the weekends and we may not have proper service. And then they don't have to be served with an affidavit, of course, unless you're requesting some type of ex parte relief. So one of the main differences between the request for temporary relief and the Rule 6D motion is that Rule 6D motion requires the service of affidavits. And those are issues that are going to be permanent. An example of a Rule 6D motion that will require an affidavit would be like a request to bifurcate the case, because that's something that is going to be permanent. And when we talk about bifurcating the case, we're just talking about separating issues. We're talking about separating the custody and visitation issue from the equitable distribution, alimony, and things of that nature. So that's the main difference between the temporary relief and any type of relief that you would get on a permanent basis. It is just that temporary, but it's really important that if it's something that you need, you do it the right way. And we hope that we can give you some tips that'll help you navigate all of that. ML?
Go ahead.
I've been practicing long enough to remember when you included the request for discovery, like right above your attorney's fees. Of course, over the last couple of years, discovery has become automatic. You don't have to request that. So please don't. If you get pleadings from someone and they're requesting discovery, it's because they have totally missed that rule, even though we've been doing that for several years.
The other thing, and I'm going to go through a motion for temporary relief somewhat quickly with you all, but one thing that drives me crazy, but also drives judges crazy, is somebody files a complaint and then they file a motion for temporary relief, which literally says, we want the relief demanded, temporary relief demanded in the complaint. That does not give your judge a roadmap. So a motion for temporary relief like this one I put up here gives your judge a roadmap of what I'm looking for at the temporary hearing. I'm asking for spousal support. I'm asking for possession of the home. I'm asking for legal and physical custody of the children. I'm requesting child support. This is what Margie talked about in life insurance. I've spent a lot of time, by the way, working on all my temporary relief requests because maintaining life insurance doesn't do it alone. You got to be able to ensure the life insurance is in place on a temporary basis. This is like a #1 issue of family court litigants. How do I know the life insurance is still in place? So my temporary orders usually have a requirement that we can obtain proof of life insurance. The standard restraints that we have as to the children, I'm constantly tweaking those. But these are what I drafted a little while back. And then you've also got requests to maintain health and dental insurance. Who's going to pay for it? Uncovered healthcare expenses of the children, they have to be covered. Your own healthcare expenses, the car costs, as Margie mentioned. Accounting, this is one of my favorites. Asking the other party to account for all the money they spent, marital money, on their paramour. I love that request, because clearly we do family court work and we like questions like that. Got to deal with the issue of debt, of dissipating assets. A lot of times now I put it unless agreed or in the normal course of business. If you look at number 13 here, you can see equity dividing payments on marital debt to include monthly and other payments thereon. One of the issues there is who's paying the Visa bill monthly, who's paying the furniture bill monthly for the furniture you bought that, you know, isn't worth what you paid for it. But these are all the kinds of things we have to deal with. If you don't request fees in your motion for temporary relief, you cannot get fees at a temporary hearing. You must request fees. Even in a case where you don't think you want fees, request fees. Do not, I think it's malpractice, quite frankly, although you can amend your pleadings later, to file a complaint in family court without asking for fees. A lot of times, if the parties are getting along, I will say requiring defendant to pay plaintiff's attorney's fees if this matter becomes unnecessarily contested. Because that, in that case, I've preserved my fee motion. But under the law, you got to make a fee request. Very important on your restraining order language. We obviously don't want to run afoul of federal laws as to stopping people from having guns. So I've tweaked that language a lot. One thing, Margie, and I'll tell y'all, is if you happen to end up in family court and you need a temporary relief motion, you need a temporary order, you need a good complaint, you want a complaint that addresses drug and alcohol testing, addresses psychological evaluations of the parties, parental fitness. We have all this stuff. I mean, I would say every day I get a call from somebody saying, do you have this for family court? And our office will share it. Margie's office will share it. So, you know, if we've given you a lot of samples with exhibits for this presentation, but if you want Word copies, we're always happy to send them over to you. One thing I do want to say, guardian ad litem. If you don't practice in family court, you probably know a guardian stands in the place of the children in court, represents the children in court. I am tending now, because guardians are expensive, and they're going to spend at least $3,000 on a guardian ad litem. I am tending, if I think the attorneys can address the children's issues, to hold off on requesting a guardian ad litem until after mediation, because a lot of times we may not need one. I mean, sometimes if it's highly controversial, but I mean, if I know the other party's an alcoholic, I don't need a guardian to get that evidence. I got it. So I think a lot of times we sort of knee jerk to a guardian ad litem in family court. I really think it increases the cost a lot. Family court cases can be incredibly expensive. And so, especially when you got custodial issues involved. And I'm not always sure there's things a guardian can do that I can't do through discovery. One other thing I'd like to include, that I include in a lot of motions for temporary release, is requiring the opposing party to sign a HIPAA release for his or her healthcare records and prescription records. And also, I often ask the court order the opposing party to obtain a SCRIPS report, which is the South Carolina Controlled Substance Report, which you can get from DHEC to do that. Because you can't get, as you probably know, healthcare records and things like a script report without the cooperation of the other party. And that way I can get it faster than waiting for discovery and after you having to draft discovery, because discovery is incredibly expensive. And in family court, informal exchange of documents is encouraged, but nobody really wants to informally exchange their therapist records usually. So that's another request I make at a temporary hearing frequently, is to sign a HIPAA release as well. Please, when you are doing a motion for temporary relief and you're pulling one that you pulled from a prior case, please reread it. I can't tell you how many people ask for custody of the child and his children because they just couldn't make that change. You know, it's just little things like that that make you look sloppy, and your clients catch it and you look sloppy. I see more probably in family court than any other kind of law. I've done mistakes like that because people are trying to keep costs down, but it doesn't take long to prove what you're doing as well. So, and Margie is going to talk about one of our favorite. Oh, the other thing I want to quickly mention. Child support and alimony can be retroactive to the date you filed the case. So pretty much in all my motions for temporary relief right now, I request support retroactive to the date of filing, because I can often get another month or two in by making that specific retroactive support request in my pleadings and then in my motion for temporary relief that delineates everything I want. It's also a guideline for me at the hearing in making sure the judge hears what I want to do. And it also gives the judge a great roadmap for where I want the judge to go. Margie, client expectations.
Yes, but I'm going to double back around and say that, the family court bar, it may seem that, it's so contentious, but just because there are so many highly contested issues, our clients can sometimes drive our litigation, which we should never let them do that. Our clients can sometimes even drive our interactions with opposing counsel. We should never let them do that. So I want to double back and say, I learned so much, not just from these type of CLEs. I learned so much from other practitioners. I mean, there are people that I have on speed dial, Melissa Brown, ML. I will reach out and say, hey, listen, I have a question about something. Can you help me? So this is just kind of a plug for us to kind of lean on each other, because the documents are there, they're available. And I want to correct something I just said. In ML, I hardly ever request for life insurance or an accounting in my motion for temporary relief. But guess what? After hearing you say that, I will do that. I have just thought that is something that, I need to ask for on a final basis, but you just explained the importance of it in a motion for temporary relief. So thank you. I appreciate that. We learn from each other. Okay, so now let's go to managing client expectations. All of our clients, they've either watched Perry Mason or Matlock or LA Law or some other judge show where they think that everything that happens during their temporary hearing is going to happen the way that, it's happened when they see it on TV. They need to know that most of the time, the majority of the time, there is no testimony taken at these hearings. I've never been to a temporary hearing where there's been testimony. I'm gonna let ML piggyback on that when I finish going through the rest of it. It is all about your documents. I have had hearings where the judges won't even let you argue. There's no argument whatsoever. It is hand up the packets and they sit there and they flip pages and they raise their eyebrows and they lower their glasses and then they make a ruling. So clients need to know, all of the options, the way it could turn out. And the way that you know that, and you can communicate that to your clients, is by knowing who your judge is. I've been in front of several judges, no argument whatsoever. So I know my packet is always on point, but it better be on point when I'm going in front of a judge and all they're going to do is read. There are judges that, will allow argument. I need to make sure that, as the earlier presenter, Chris said, write it down. I script every point that I want to make to the court so I can make sure that I include everything. So we have to let our clients know what the expectation is in terms of what's going to happen when they appear with you in court. Now it's a whole different ballgame because, of course, we're using Zoom. I've had temporary hearings where I've had clients in my conference room or in my desk, near my desk with me. I've had temporary hearings where I've had clients who were out of town and they had to log in on Zoom. So it's a whole nother set of expectations we have to give to them. I actually had a temporary hearing. It was in Lexington County, and the other party was making all kinds of faces and making noises, and the judge had to say, listen, you need to tell your client, calm down. I can hear everything that they say, and I see all of these expressions that they make. Of course, you could also do that, in live hearings. So make sure they know, how to act, which is not to react, not to make faces, not to roll their eyes, not to lay back in a chair, which is things that kill me, to listen, to pay attention, to take notes. Those are all things that I tell my clients with regard to temporary hearing, because I need them to listen while I'm talking. I need them to listen while the other side is talking too, so we can get as much information that we can, that we need to use on rebuttal. Make sure we put forth all of the points we want to make for the request for relief that we're seeking. How to dress and behave, Lord. as I sit here today trying to navigate 2 pairs of glasses because my eyes are so bad and I refuse to wear bifocals, I think it's so important that we let our clients know how they should carry themselves. Dressing is important. I think the first time I did this with ML, and I think we had, oh God, was it Julianne with us? I was wearing a yellow dress with feathers. I was a client that day. Please do not have your clients come to court with, or come to do a Zoom hearing with a yellow dress with feathers. I wore that dress on purpose. Make sure that they dress appropriately. There are rules that even the courthouses have, no flip-flops, no shorts, no tank tops. All of that stuff may be a given statement for some of your clients, but there may be other clients that don't have experiences that require them to dress in any way better, any different than that. So it's important that we tell them how to dress, how to behave, where to go. I've had clients when we're talking about getting ready for a temporary hearing, and they're like, oh, do I need to go down to the courthouse in St. George? No, you go to 212 Deming Way, in Somerville. So don't take for granted that they know the difference between where the family court is located and where, Dorchester County Common Pleas Courthouse is located. So we need to make sure that they know where to go. Again, we will let them know that these are not testimonial hearings unless it's been requested by motion. And you don't need an entourage. It is so good to have support people there. I know it's good to have like your best girlfriend who's been kind of holding your hand throughout the entire process, or your best guy friend that's just been a really strong advocate for you. But when you get to that hearing, you need to be prepared to hunker down in the last couple of minutes before that hearing with your attorney. That is going to be the first time that your attorney gets a hold of all of the packet, the affidavits that say all the bad things that your client has done, the financial declaration of the other party, anything that's related to the matters that are requested, matters related to custody, finances and things of that nature. When you get there with your client needs to be prepared to hunker down with you and go through those affidavits and say, no, this isn't correct. This is, this income is incorrect and things of that nature. So you don't want your clients to show up with an entourage, because then that's going to kind of interfere with their ability for you to have their undivided attention.
And we gave you an Exhibit A that my office does that tells clients, 101, but don't assume they read it, because let me tell you, I've had clients show up, professional clients, with their boyfriend. You do not bring your children to court unless a judge has ordered a child be brought to court. I don't want a child at court, and I've had professional clients show up in Bermuda shorts. So this is why we wrote this, come to family court 101. If you're dealing, in other courts, maybe not so much in criminal, but if you're at least in civil courts, hopefully people know. But it is just a challenge. And I have never seen a judge rule in favor of my client because they decided to bring everyone they've known since they were 3 years old to court. I tell my clients, you got me, that's all you need. So, and that's really how I feel about it. A lot of times I'll bring a staff person along to manage the client because they drive me crazy some days. But all right, we're going to talk about how much time you requested for family court. The standard temporary hearing is 15 minutes and you get 8 pages of affidavits. That is rarely, if ever, enough. More than 15 minutes, there is no limit on the pages you have of affidavits. I have enclosed something you should read if you're ever in family court. It is a Supreme Court order that delineates procedures for a family court hearing. I read it before every family court hearing. I have it in court with me as well. It addresses a lot of things as well. One thing to know about affidavits, you can attach whatever you want to them. The documents that you attach to your affidavits must be verifying the information in the affidavits. That is particularly important when there's an 8-page limit. One thing I will do at temporary hearing after temporary hearing is get the attachments to the affidavit stricken because they're not verifying the information that is in the affidavit itself. Which again is one reason you really need to know what you're doing in the family court, because what people like me and Margie do, or Margie and I do, is get a lot of things you think you're getting in, not coming in. And we'll talk about that more in a little bit. you do need to designate opposing counsel if you know that is required by the Supreme Court order. And so, and you also need to know when you walk in a courtroom, and this probably can come up a little bit later, but the judge is going to ask what you've resolved. The Supreme Court order says you're encouraged to consult with one another prior to the hearing to try and resolve issues. And you should, and I had an attorney last year say, if we can't resolve all the issues, we won't discuss any of them. And I thought, this is insane. I mean, I know we can resolve that neither one of us is going to get fees at this time. I know we can resolve standard restraining orders. They refused to talk to us. So when we got to court, I told the judge, I said, you know, Your Honor, we were willing to resolve these 5 issues, but opposing counsel said he would only discuss global relief. And there was not a happy judge. So, you know, and it was ridiculous. And hopefully the person learned the lesson. I want to get as much stuff out of what the judge has to decide as I possibly can, because no one knows your case like you do. Nobody does. And you should know it really well. If you need more time, you need to request 30 minutes. Check that cover sheet. These days, I'm requesting 30 minutes plus 15 minutes to accommodate a virtual hearing. So that means I get 30 minutes to hear, but then there's additional 15 minutes to get everybody onto WebEx, because it takes forever in family court to try and get anyone on WebEx, because none of our clients seem to have ever used anything virtual before. So make sure you think through. It is rare, if ever, I send in a temporary hearing request with less than a 30-minute request. 30 minutes is pretty much my standard, but you gotta write it in. And Margie's gonna talk about affidavits, which are the most critical thing for a temporary hearing. And Margie.
Okay, and I'm just going to double back around to talking about the Supreme Court order with regard to the exhibits and things of that nature. That you have to offer the verification for the information. Know your rules of evidence before you go attaching screenshots of pictures. Before you go attaching text messages, make sure that you laid a proper foundation for all those exhibits in your affidavit, or else they are going to get kicked out. Now, looking at the affidavits, one of the first things that I do when someone comes in, and I know we're getting ready for a temporary hearing or that I'm going to request a temporary relief, I create what's called an affidavit go by. And it basically is just the case caption, that paragraph, which is the sworn paragraph that talks about everything is true unless it's based upon information and belief, a whole bunch of lines. And I can send it to my clients as a Microsoft Word document. And that's kind of the first way that they begin to craft their affidavit. We talk about what the affidavit is going to contain. We talk about they're going to put in information that's going to align with the request for relief. But just because it is easier for me when I get ready to put this together in my packet, I send it to them as a Microsoft Word document. If they're not that savvy, then I just print it and I let them handwrite it. But I know that after it's been handwritten, that someone in this office is going to go back and type it. I don't think I have ever submitted a handwritten affidavit. If I have, it was probably very early in my practice. And it was probably because I just had no other way of getting the affiant to put it in a different format. It certainly requires the court to go through great pains to try to read it, you too. But I will tell you, this is another trick I learned actually when I worked at Savage and Savage. If there was a handwritten affidavit, then I would just go ahead and type it. Now, the handwritten affidavit, of course, it has to be signed, it has to be notarized, but then I could just type verbatim the words that they wrote down on paper so that it was just easier to navigate. But they should not be handwritten. Again, include language, the facts are true and correct. That's what that initial paragraph is. Personally appear before me the defiant who states that everything in this affidavit is true and correct, except for those statements that are based upon information and knowledge. That paragraph has got to be there. And then of course there is the signature block at the bottom for the notary that also says on this particular date, this person was sworn and they, subscribed that the information in this document was true and correct. And then it's notarized.
Margie, let me just interject a second. Right now in family court, we're under COVID procedures. So under the Supreme Court's order, which has been amended multiple times, we are now doing affidavits by certification in family court. If y'all need sample anything by certification. My firm's got it all. We've actually shared it with most of the family court bar. But financial declarations and affidavits, two of the two most critical things in family court, are being done repeatedly now by certification. And whether it says to attach a driver's license or not, we're attaching driver's licenses to absolutely everything right now, just because we don't ever want to have a problem. Margie?
And I would guess that the premise behind doing it by certification is that it might be difficult for someone to actually get to a notary. And yes, we also are requiring they attach a copy of their driver's license. I will tell you what, even though COVID has just created so much hell in all of our lives, with regard to being able to resolve some cases, through the COVID packet. And ML, I think we probably need to make sure that people have that as well. The COVID packet that allows people to get agreements approved, and to get a divorce. It has really worked wonders in terms of, instead of people just having to sit around and twiddle their thumbs while they're waiting for the courts to open back up, being able to send these documents again through certification, so that you don't have to go through the extra step of making sure you have a notary, allows the cases to kind of keep moving. So continuing on with the affidavits, there are certain requirements with regard to the way that the page should be set up. Yes, it is all important because, again, you want to, temporary hearings is already trial by ambush, meaning that you're not going to really know what the other party is going to say about your client. The other party's not going to know vice versa until you get into that hearing and you start zipping through some of those documents, or when you get them through Zoom, which they have to be submitted, 24 hours before the hearing. So it really is very important to make sure that everybody is at least on the same page as it relates to the requirements for the documents.
And one reason spacing is so important in family court is you got an 8-page limit,
Yeah.
and someone does single spacing, they're getting extra space. And I have kept affidavits out on that rule as well, and on the margin issue.
Yeah.
So, I know it sounds unfair, but people are taking advantage. I'm sitting here making sure my spacing's accurate, and I don't have extra room, and somebody else is just doing their single spacing, and they're wider, and they're, thinner margins. And it's unfair to my client, because the only evidence a judge is looking at a temporary hearing, unless you've got testimonial permission, which is rare if ever, is these affidavits.
Right.
And they are making serious decisions that affect support and custody and everything else for a year or more. And right now we're a year backed up from trial. So we're looking at 2 years. And of course you can get adjusted temporary relief. That's a whole other topic, but go, Margie.
And I am not beyond holding up, my affidavit that I know is got the appropriate spacing, and somebody else and say, hey, this doesn't look right. Your margins look to be a little off, whatever, because this is the thing. The court is going to make life-altering decisions, yes, on a temporary basis about your client. I cannot tell you how important it is to make sure that you do them justice. You do a good job. You follow the rules, but you advocate for them. Whether that advocacy comes in the form of excluding documents, excluding the things that they want to offer as evidence, that's what you have to do. So again, margins, not less than 1.5 inch spacing, 1 inch margins minimum of 12-point type with regard to the font. That is really important. I always use Times New Roman font. ML, I don't know if there's a designated font, but before you answer that, this is a question that I have. What if I've got 8 pages of affidavits? My client's affidavit is 8 pages, but the signature block is going to be on page 9. ML, have you encountered that, and what would you do if you saw that?
I would move to strike. Fit it on.
Yeah, fit it up there. So see, listen, we learn from each other. The family court bar can be collegial and fun. I think we all really like each other. It's just sometimes when we get down in the weeds with regard to some of these issues. But yeah, and like I said, I ask questions all day, every day. I am not beyond texting anybody and saying, hey, I have a question about this particular issue. What do you think? And there's always somebody that's willing to help. So, affidavits. Okay, continue. Hearsay rule. Please, please, please. I have actually, before I've even begun my argument, I had made a motion to strike all of the hearsay, because I know it's in there. And of course, I think I had Judge Macklin say, well, Margie, why don't you point to what particular hearsay you're talking about? And again, that's when getting those documents and going through them to make, my opposing counsel affidavits is so marked up, affidavit for the other party, because I'm just going through making all these notes, because again, it really is trial by ambush, and you don't really have, a whole lot of time to prepare and to try to get your argument together to refute some of this stuff. So make a wholesale motion to exclude all hearsay, but then as you go through, just, hey, out of court statement, there's no exception to this hearsay, I move to strike it.
One of the things you see in almost every affidavit is, my child told me that. Hearsay. Now, my affidavits say, my child came to me really upset and crying and said, yes, present sense impression, excited utterance rule. Now, of course, when my client says, my child told me this, my question to my client is, how was your child when she told you this? Because it's got to be true. I can't make up that the child was upset and crying. But, and then on this rule 7, certain documents are admissible. You've got to know this. You cannot just stick into family court the latest grades that you printed off the school website for your child. You can't hand up to family court the therapist records, because rule 7 lets you know that a child was treated and for what. But the therapist records can't come in. So if you want the therapist records to come in, you've got to have an affidavit of authenticity from the therapist. But then again, you got the page issue. So ideally you'll get an affidavit from the therapist.
Right,
But I have kept out therapy records. I just cite rule 7, family court rule 7. I have kept out a print off of grades from the screen, because those don't just come in. It has to be a certain type. It's got to be a report card or an interim report. Same for children's school attendance. I think what we're really telling you is, don't play in the family court. There is a unique set of rules. It'd be like me going to criminal court. I'd have no earthly idea what I was doing. And so, you just can't play in the family court. I think that's a lot of what we're saying. Although we'll help you. If you want help and you get a family court case, you take a pro bono case, we're here to help.
Yeah. And even with regard to, incident reports, police records, if you don't have that affidavit from that officer that attests to that information that's in there, you can't get it in. This is the practice of law is just that. Things that, people used to get over on me about, when I first started practicing, they can't do that anymore, because you learn the rules and you practice long enough with people that will help you. So it's really important that we maintain, I guess, create and maintain the collegiality in this bar, so that we can all help each other. Because at the end of the day, we're all just advocating for our clients and for what's in our clients and the children's best interest. It may look different from your thoughts and opposing counsel, but there's always a way to try to resolve things that can be resolved. And lastly, if you do have a reason to include hearsay, you must in some way identify it as such and be prepared to argue for its admissibility. So again, you just need to make sure that you know the rules. The rules are so extremely important, and they're not there just to occupy space in a book. They are there because your case will rise and fall on your knowledge and your practicing of the rules, okay? All right.
Financial declarations, as important as affidavits, they're also evidentiary. They are under oath. They are sworn documents under oath about your financial condition. You got to have one at a temporary hearing. Page 1 is your income, your client's income. Page 2 is your client's expenses. Pages 3 and 4 are the marital assets and debts addendum pages. You need to prove these. You probably need to do them for your clients because they have no earthly idea what in the world they're doing. So my favorite is I've got a couple that make between them $85,000 a year. And I look at the wife's food budget and it's $2,500 a month. And I'm thinking, there is no way you spend $2,500 a month on food for you and your 3 children. And then we get the, I've got 2 teenage boys argument. So I go through my clients' budgets on page 2 with a fine tooth comb. The other thing I'm looking is what are their expenses on page 1 and what are their, what's their income on page 1 and what their expenses are on page 2. If they're, and I especially look at this when I get the opposing party's financial deck at the hearing. So I look at their income on page 1, and let's say it nets a month to $5,000. And on page 2, their monthly expenses are $10,000, and they have no credit card debt listed. Somehow they're paying their bills without going into debt. It's not accurate. So financial declarations are a wealth of information about the other party. Just a little tip: if I can't come up with a food cost for a client, the USDA has a food chart. It does it by age, family size, whether you're on a budget plan or an organic food plan. And you'll be shocked at actually really how reasonable it is. And that's something I use. I also look for double hits on the expenses. So if they list the HELOC under the mortgage category, but they also list it as a monthly expense. I had a case recently that I actually won, basically, at a temporary hearing. The case settled globally soon after, with all of my clients' fees pretty much being paid. I had a dad come in who wanted a reduction in child support, and he claimed his income had dropped. So I looked at his page 1, I looked at his page 2. Well, page 2, he had put down the entire cost of his rent, but dad forgot to mention to court that he had a new spouse who was a nurse who certainly could contribute to the cost of rent, and why my client's children's father was paying for his new spouse but couldn't pay for his children was unclear to me. He also listed that he had $1,500 a month in credit card debt. Well, when I looked at his total credit card debt, the whole balance was $1,500. And clearly it was double dipping between his monthly expenses and credit card bills. So I reworked his financial declaration completely before the hearing, showed the judge in detail how he could continue to maintain the same level of child support. His child support got maintained by the judge. And my client got $5,000 in fees and a bunch more to settle the case. So knowing how to read a financial deck, knowing how to tear the other side's financial deck apart is completely critical. Most of your clients will not, you ask your clients how often they get paid, they say twice a month. Quite often it's every 2 weeks. They don't understand the difference. You got to look at their paycheck. There are things, the current family court financial deck is horrible. I'm actually chairing a committee to redo financial declarations in the family court because they're so bad. For example, it doesn't include a category for homeowners insurance, leaves it off. Doesn't include a category for HOA fees, leaves it off. There's all kinds of other problems with it. There's a wonderful category of laundry, which, you know, everybody puts like, and dry cleaning, which is like $10, complete waste of space. I don't know why that's not in household expenses, but anyway, you also want to take some time delineating between marital and non-marital assets. I've given you an example here of how we do it, trying to break things out. We asterisk a lot on financial debts in my office because it's the financial declaration itself does not really do a good job of permitting you to explain things for your client. There's a huge amount of problems. If you are doing a financial declaration for the first and second time and you have questions, please contact someone who regularly practices in family court, because we will help. We know the tips and tricks. I'm giving them some of them to you right now, but we certainly know them and we're glad to share them. Margie?
Okay, so now let's talk about service. I kind of hit on this a little bit in the beginning because you got to make sure you understand that the rules for service as it relates to this motion are a lot different. Now, the Supreme Court order says that in order for both sides to have adequate time to prepare for the temporary hearing, service of the motion for temporary relief should be completed as expeditiously as possible. I have a couple of temporary hearings that are scheduled for March. I've already gotten my motion scheduling them. I've got the court date. It's going out the door as soon as I can get a cover letter and get it to the other side, just because, again, that is being in compliance with the Supreme Court order. Unequivocally, without a doubt, though, the Supreme Court order Rule 21A states that you should not serve these things should be served no later than 5 days before the time specified for the hearing, unless a different time period is fixed by the order of the court. And that is 5 business days, okay? When you look at the computation of time and the rule that deals with that. So you need to make sure that just because you've got 5 days, you know, if you've got a hearing that's scheduled for, February the 10th, and you're thinking, oh, I'm just going to make sure I get this served by February the 5th, you got to consult your calendar because there's a rule that talks about the fact that when it's less than a certain number of days, you don't count weekends and holidays and things of that nature. So you want to make sure that your hearing goes forward. So again, the general rule is as soon as you get that motion that's been scheduled, get it out, get it served, file your affidavit of service or certificate of service. But it absolutely unequivocally must be done not less than 5 days unless the court sets a shorter time period. And then we look at Exhibit C, because in fact, the case that ML and I just resolved, I actually filed an ex parte motion for emergency custody, expedited hearing. I mean, everything, the whole kit and caboodle. But guess what? I didn't get it. So what I was asking the court for was I was asking the court to change custody as it relates to these parties' children, and also give me an order for that, and also to set this hearing with a shortened notice. The shortened notice will be less than 5 days. Honey, I didn't get any of that, which is okay because we got the case worked out. But the important thing is you need to make sure that you serve that temporary motion with that hearing date as soon as you get it. But if you don't get a shortened time, 5 days is the absolute requirement. And if you can't show that you've got 5 days service, you're not going to go forward with that hearing. There's a great example of the ex parte order that's in Exhibit C. It talks about plaintiff having sole custody of their minor children, pending a hearing on this matter. I'm gonna make another note about that from another practitioner. Unless you get an ex parte order that shortens the time for service, you need to make sure that you actually serve within that 5 day time period. With regard to ex parte relief, and I'm sure we're going to talk about that later on, but I just want to throw in another practice point. There was an ex parte order that I've seen and been involved in that was filed, and the language in that ex parte order was basically the same as this one, that plaintiff will have sole physical custody of the minor child pending a hearing. But this practitioner went a step further and said pending an order. So basically, the order says if this person gets custody of this child, this person will maintain custody until there has been a subsequent order. So another practice point, again, when you're filing an ex parte, you know, hey, you're going to do it right. Ask for everything. Ask for custody, and for that custody to be maintained with your client until there is a subsequent order. Thank you, Jeff Slider. Okay.
Thank you, Margie. So these are some things that you sort of need when you're getting ready for a temporary hearing. Here's your checklist. First of all, the minute you get retained in a case to represent defendant, you need to send a notice of appearance. My little practice tip is you send a spoliation letter to tell them to preserve all their electronics. We do that as a standard matter. If we're representing the plaintiff, we serve it with the complaint. If we're representing the defendant, we serve it when we appear in the case. I've given you a sample spoliation letter. You probably need to file a return to the request for temporary relief. It's a good thing to file a UCC-JEA affidavit that ensures the family court, when children are involved, does have jurisdiction in South Carolina over the children. I actually plead that in my complaint in any case in which there's children. Margie, I actually learned that from Margie a few years back. You get your answer and counterclaim filed before the temporary hearing. You just need to have it in there. Settlement proposal. So at any contested temporary hearing, I always make a settlement proposal in writing ahead of time, and I present it to the court, and of course give a copy to opposing counsel in a sealed envelope, because the court can consider it on the issue of fees. So when I send in a settlement proposal, and it's hopefully gonna be near where the judge ends up, it helps me get fees. Again, sealed envelope, handed up. The judge will look at it once they rule. We already told you that you're encouraged by the Supreme Court order to speak to opposing counsel to try and resolve things before the hearing. Supreme Court order encourages it. Try and agree on your mediators and guardians before you get to court. There is no reason that two smart family court attorneys shouldn't be able to agree on a guardian to start after mediation, as I said in most cases, and to agree on who you mediate with. There's absolutely no reason you shouldn't be able to do that. I actually, going into every temporary hearing, going into every temporary hearing, I have a checklist of things I've agreed to with opposing counsel, because the judge will ask you at the start of every hearing. Fee affidavit, you're not going to get fees without it. So make sure you have a fee affidavit at your temporary hearing, include the potential time to argue and be at the hearing and to prepare an order. You're required to have a proposed parenting plan. You're required to have a background information form. I always have a brief for any unusual fact pattern or issue of law. Between me and Margie, we've probably got briefs on every single issue that can come up at a temporary hearing you wouldn't expect, or we can find you one. I just sent a friend the other day a brief I'd done on relocation on a temporary basis. We'll never, ever go to my temporary hearing without my well-tabbed, well-loved rule book. And of course, you need to have copies of everything under the sun, because even if you filed the complaint, I can promise you the judge is probably not going to have it. And so I take extra copies of everything we filed, multiple copies of everything that we're going to have for the hearing as well. Margie is going to talk about being organized.
Okay, I'm going to double back though and talk about return. And again, when I first started doing domestic stuff in 2008, I mean, it was totally, just trying to wing it. I think it's great, to have mentors. I was in a building with some guys that have been practicing for a long time, Ben Mack, Dave Devane, and Walter Amiga, and certainly they were my mentors, but they can't hold your hand, every step of the way. Because I remember going into a motion hearing and not having filed a return. And it's like, dude, you ain't getting nothing because you did not file a return, because your return is where you bring the issues that you want the court to address. So it is so very important. Again, we just can't take this stuff for granted. These are people's livelihoods, that we're dealing with. So you've got to make sure you do it the right way. So make sure you file that return, make sure you file that return and that it is timely. Because, I've also gone into hearings where I've got the return and I'm handing it up. And I had one judge say, listen, those matters are not before the court because you did not file the return. The return has to be filed at least 2 days before that temporary hearing. So again, a lot of things, you learn along the way, and it's good to have mentors and colleagues that'll help you. So being organized, even as I think about the first packet for a motion for temporary relief that I did, I think it was just papers stapled together, paperclip together. I've just learned throughout the course of the practice how important it is to be organized. We do a table of contents. We have tabs. There is one judge that I am not going to mention that I love him to pieces, but he hates my notebooks. So every time I walk up and I'm handing up my handy dandy, blue notebook for the court, my notebook is blue for the court because that's the original one and I've signed it in blue. When I go hand it up, he's like, we're going to just throw this away. So since I have learned that whenever I go in front of this judge, I don't have a blue binder, but I have everything in one of those huge black bulldog clips. Still got my tabs, still separated, still organized, still got my table of contents that lists all my documents. My table of contents also lists all my exhibits. So when I am saying, okay, beg the court's indulgence, Your Honor, please would you turn to section 3A of my client's affidavit, which shows the screenshot of blah, 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 that I've laid the foundation for it to be included. So be organized, and it just helps you. It just helps you even as you're making this argument. Again, this is trial by ambush. So the other party is going to say all the stuff that they need to say to get the relief that they're requesting. If you know that your packet is together such that you can turn to section 4C, which is the affidavit, of someone else with an exhibit that refutes what they say, make sure you do that. One of the things that I always tell my clients, everything I say in this affidavit and that I say before the court, I want a piece of paper to back it up. I want to be able to show, yes, this is credible information. The proper foundation has been laid for this document to be attached, and it happened or didn't happen. So that's one of the things I tell my clients, and being organized will just help to guide you directly to those spaces where that information is. Again, some judges like tabs, some do not. That goes into the section of know your judge, know what's going to be easier for them to manipulate, know what's going to make them feel better, or make them not offend them as it relates to the information you give, especially if you know that there's a certain way that they like it. It can only help your case. Again, have a packet for the judge and opposing counsel ready before you walk into the courtroom. 9 times out of 10, you're exchanging this stuff in the lobby. When I first started practicing, that Donnie Gamage, he got me really good because he did not give me the packet until he put it on my desk. And here I am looking at this horrible affidavit from a private investigator about my client. And it's like, okay, what do you do to try to resolve that? So as much as you can exchange that information in the lobby, you know, you're going to have to. If you go in front of Judge Macklin, she's going to say, did y'all have a chance to exchange packets? No, we didn't. We'll go back out and exchange them, you know, because maybe there's some common ground that you all can come up with. But again, be organized. It's only going to help your case. Emil?
Thank you, Margie. As we've said, a lot of times, like Margie and I did, we reach agreements before the temporary hearing. There are attorneys that literally, I've seen it, email the judge and say, Your Honor, we will not be appearing. And I can promise you, you're going to get a snippy email back saying, you need to request my permission not to appear. So, Your Honor, we've reached an agreement. If it's okay with Your Honor, we would like to submit an agreement in lieu of, an agreement / order in lieu of appearing. They'll say yes. Trust me, they want you off their docket. Same thing if you've agreed to a continuance, you got to ask the judge. Got to get the order to the judge within 30 days of the hearing. That's a rule. You know, preferably get it there sooner. The longer you delay on getting an order written, as you all know from every field of practice, the more likely it is not, you know, to fall apart. So you got to determine what judge's docket you're on. In family court, I don't know about the other courts. We have no earthly idea till the Friday before, somewhere around 10 o'clock. Sometimes we can call and find out ahead of time, but usually it's the Friday before as well. Obviously, Margie, you're going to talk about knowing your judge. Oh, I did want to say we did include a sample temporary hearing submission index as well for everybody. Margie?
Yeah, knowing your judge. I kind of hit on that a little bit ago, but that judge that does not like my handy dandy blue binders, but it's okay. Know what preferences your judges have. It's so interesting. You know, I've had a couple of cases in federal court, you know, and every once in a while you get a memo that talks about what the judge's preferences are, you know, as it relates to appearances, documents, and things of that nature. So it's important to have that same information about the judge that you're going to be appearing in front of. It used to be that when you got your temporary hearing, it would state the name of the judge. Sometimes it does, sometimes it doesn't. Because dockets change, I always go and check the docket, you know, a couple of days before the hearing, if it's out, so I can know who I'm in front of. I will be totally honest with you. That helps me to determine, again, what my packet needs to look like, what information that I need to, how I'm going to fashion my argument. I'm going to zero in on the issues. I'm not going all the way around the world because it's like this judge wants to get to it and keep it moving. Whether the judge is even going to allow the parties to make any argument. That is very important because, again, you want to be as prepared as you possibly can in every single way, not just with regard to preparing your client, where they're going, how they're going to look, who they're coming with, preparing your packet, making sure your affidavits are on point. You've laid the foundation for all of your exhibits. You're not going to get your stuff kicked out because you know it's inadmissible because of hearsay, rules of evidence, things of that nature. Know your judge fits in that category as well because, again, it can only help to make the experience just, you know, smoother for yourself, smoother for your client, and hopefully you have the outcome that you want and you seek. And don't argue after the judge rules. I mean, my goodness.
That's a family court rule.
Yeah.
That's a rule.
Can I say one more thing, Your Honor? No. Stop talking.
but that's an actual rule. And just so you know, there are new county-specific COVID procedures for family court. So we have included Judge Martin's order, and we've included for Charleston County and Judge Landis's for Berkeley County. And when you heard Margie mention earlier, the 24 hours before the hearing submission rule, that's where we're pulling it from. So you got to know these orders. There is a family court listserv in Charleston County, which is where we find out a lot of this information. Rules are changing constantly in family court. You'll see the practitioners obviously trying to work together. And as Margie mentioned earlier, we can now actually do final hearings for approval of agreements and divorces and name changes, all by paperwork submission. So if you happen to be in that area, it's not before y'all today as the topic, but we have all the documentation you need. And the judges are very funny about this. They are, you know, trying to be really careful because of due process. So I think I've got the forms where they work. We seem to be getting things approved. So if you're doing a divorce or approval of an agreement or a name change and you need the final hearing documents, we have got them in my office and are happy to share them. Margie and I are about out of time. We are happy, Mary Lee, to take questions anybody has about temporary hearings or family court in general, to the extent we can answer them.
There were a few questions submitted. Thank y'all so much for the presentation. The first question was, has a family court filing procedure for motions changed before you could just file the motion and write the date and time in the motion book?
It depends on the courthouse. Some in Charleston County before COVID, you were able to go down there and fill in the book. That is not happening right now. They're emailing you to schedule usually.
And then the other question was, what do you think about the trial by ambush aspect of temporary hearings? Do you believe a briefing period with response time should apply in order to allow for a better opportunity to respond to allegations, given the consequences of a temporary order on the parties' lives?
Margie?
Yeah, I think in a perfect world, it would be great to be able to vet all the issues, to go through all the allegations, to prepare your defense, of allegations, or, to prepare your prosecution of certain allegations. But if we had all the time in the world to do that, you would never get the relief that your clients need. I just think that, I'm kind of like a rule girl, and I'm like bloom where you're planted. This is where we are in family court, unless something changed. ML talked about working on the committee to review the financial declaration. Unless something happens that changes the way this trial by ambush happens, unless something happens to change it, we just kind of have to live within it. There are just so many tools, again, and resources out there. There's a family court tool book, and I don't know if the South Carolina Star Bar is still publishing it. I have one from years ago. I think David Hazelden sent me one by email. I have Melissa Brown's old version. So there are tools out there that you're just going to have to use to advocate for your client to get the best possible result that you can within the confines of what we have right now. And, certainly if it changed, it will certainly help all of us with regard to, again, making sure that we could address all of our client issues and allegations. But, if you deal with 10 allegations, by the time you get to the hearing, there's probably going to be 10 more that you got to figure out how to navigate. So
it's incredibly hard. I mean, literally, it's a good thing I'm a speed reader, because I'm literally scanning tens of pages of documents the minute I walk in the courtroom. So it's not good. But there's a lot of times it's a time crunch in family court. What I will say is good practitioners do everything we can to avoid temporary hearings. Yeah. We really, really, really do. I mean, we're prepping for them. I got a whole team over there prepping affidavits, financial decks, running around while I'm negotiating. So, my goal in almost every case is not to go to court, because I know every single nuance of that case. And a judge, and we have we're really blessed in Charleston, Berkeley, and Dorchester. We have really good, really great family court judges. But, they're not going to know the minutia like we do, and why we want the, kids on these days, and the schedules and things. So, a lot of this informal discovery, exchanging things ahead of time. But the other hard part of family court is it's so emotional, and people want retributive justice. And they want a judge to tell them what is going to happen, and I feel like saying, well, I don't know the judge can know your case better than I do, but if you really want to go to a judge, I think, we really are counselors at law in the family court. We do a tremendous amount of, counseling our clients. I think half of what we do is hand holding and consoling. I mean, I had a client, a parent teletherapist this week, ML isn't, sitting here and talking me through all this. And I'm like, well, that's what my paralegal does, and your counselor and your psychiatrist, because ML is trying to settle your case, so you don't end up spending everything you have trying it when you need to settle 3 months ago. But it's a very emotional field that we work in. And the trial by ambush part doesn't help either, because when your client's supposed to be holding it together in family court in front of a judge, and they're seeing what the opposing party just filed about them, it's real hard for them to keep a poker face.
Are there any other questions? You can submit questions through the question and answer feature, and they can be anonymous as well if you don't want to put them in the chat feature. Otherwise, thank you so much, Margie and Mary Louise. And the materials that were referenced, they are on the CLE's website, the CLE calendar where you registered. The materials are linked there today. So if you would like to go and look at the materials, they are there. And we have launched the first poll, so please answer the poll to confirm your participation. And now I'm going to hand it back over to David to introduce Jay McDonald.
Thank you, Mary Lee, and thank you, Mary Louise and Margie. That was a great presentation. The next presentation we have is going to be by Jay McDonald on civil matters. Jay is originally from Charleston before traveling up to the upstate for college, where he attended Clemson University before the University of South Carolina School of Law. After graduation, Jay began his practice at Clausen & Stobbs in 1988. Jay represents defendants in personal injury matters such as premises liability, catastrophic injury, and product liability cases. Jay is also a certified mediator and has mediated similar cases to those in his practice area. And Jay is going to share with us some of his experiences as a defense lawyer and mediator in personal injury matters. So if you'll please welcome Jay McDonald.
Good morning, everybody. I want to start it off by telling everybody happy Friday. And David, the thumbs up, you can hear me okay? All right, y'all, everybody will learn how
Jay,
yes.
I don't mean to interrupt you, but there you go. Half your face was cut off, so folks might want to see the whole.
All right, thank you, sir. You know, I first learned that term about Happy Friday way back, and some of y'all may have even been in that class with Professor Spitz, you know, back on first year law school and teaching property. And each Friday he would come in and he would be so excited about it being Friday that he made even property exciting on a Friday. So I hope my goal today is to sort of, I don't know if I can make this topic exciting, but at least I hope that y'all will get something out of it as we go through kind of what I was asked to talk about. And I sent a kind of the title of what I was going to talk about was the practice of law from a middle-aged, middle-aged. I'm not old yet. I'm just middle-aged. Insurance defense lawyer, mediator, kind of a hodgepodge of topics in really Jay's world of personal injury. And one of the things that I asked David, and I'll ask you all because of my technology insufficiencies, is, you know, I'm gonna base this really on my experience. And so it's kind of like J-Law, which might not be accurate. And if I need to, you know, if it's not quite right, tell me. But it's really just been my experience of practicing law, because I've got a lot of experts here at Clausen & Stobbs that I can utilize to ask for help, you know, when I don't know an answer, and most of the time that's it. You know, that I don't know, but somebody does. So, you know, always keep that in mind. And where the other place I wanted to start with, and some of y'all may get this, you know, I want to talk about a little bit about 2020. You know, the year in review. I got a quote from a great philosopher. The only disability in life is a bad attitude. And if y'all know who that philosopher is, some of you may, because I'm saying it and starting it out, was Dabo Swinney, the coach of the Clemson Tigers. And, you know, when you think about 2020, we've all had our own experiences personally, our own experiences as a lawyer, as a judge, as you know, within the practice of law. And, every time the Christmas and the holidays and then the new year come around, I kind of reflect back, even without a pandemic, about, the year that we've had. And the thing about, for me, the gratitude I have for 2020, I don't want to talk about all the, kind of the hurdles we all had. And this may sound corny, but I've just been overwhelmed at how, with the folks that I've had to practice against, the attitude they've come in with trying to work out cases, and I'm talking about as a defense lawyer or as a mediator. And I'm talking about just about everybody. I mean, there's certain times and certain situations you just can't do anything about the facts of the case and, one perspective or the other. But I've been amazed at the ability to work cases out. I know, I was grateful that we were determined somehow to be, at least in my case, essential. And I kind of joke about that. But when this all started up, I really was worried about, how was my practice, how was Clausen and Stobbs going to continue? We weren't going to have jury trials. Again, I'll go to my, inability or maybe just lack of learning about how to really utilize this technology. And I've learned a little bit more about it every day. One of the things that I'm really grateful for is Zoom. I have done everything from depositions, mediations, hearings, via Zoom. And, in the beginning part of COVID, I had used video conferencing because I was kind of lazy going to out-of-state experts' depositions. And I learned from that I could prepare for an expert in advance, get the exhibits. So I had a little bit of experience with that. But this Zoom technology, the WebEx technology, I'm not as comfortable with WebEx, but I've learned to become relatively comfortable once I'm in, to utilize the Zoom capabilities, particularly as a mediator, where you have to try to have the breakout rooms and those sort of things. In the beginning of the pandemic, when I look back at 2020, I had an inventory of cases that were really kind of already ready to kind of get to that mediation stage. And, and we stayed busy, and we were able to get a lot of cases moved, maybe paying even too much money. I know some of plaintiffs' counsel won't agree with that. But then there was kind of a lull. And then I, heard my plaintiff's attorney friends, worried about, the isolation that this, this pandemic has caused. People weren't going to the store, so they can't fall. People weren't out in the traffic, so they can't have wrecks, being kind of, funny, so to speak. But there was kind of a lull for both plaintiff and defense. And then it kind of picked up again. And then towards the end of the year, this year, there was a little bit of a lull. But I look back on it, and really and truly, and I'd ask that each one of you think about this. And everybody's practice of law is different. Their experience is different. But I met my goals. Both as a litigator and as a mediator, I really felt like thanks again to Zoom, and thanks again to everybody's attitude being proper, trying to get cases worked out. So, there's been some positivity in what is probably, at least in my lifetime, maybe not my folks that lived through World War I and World War II and the Spanish pandemic. But you all have made this where I can work, and I really do appreciate that, and I hope you all do too. For today, I've got a list of things that I'm going to talk about, and really what I'm most worried about is me talking. I did not have anything to share on the screen. I was more worried about running out of things to talk about than I was really what I was going to talk about. And, that way, this way, I usually, when I do this live, I would want to promote audience participation. And, you can do that. I know when you're on a Zoom, it's pretty easy to listen and not really participate. Everybody has their own method of doing things, but certainly if I bring up a topic and, maybe you've had a different experience, and, the way that I learn and love the practice of law is the only way I learn how to do things every day is learn by experience. And I have not come close to experiencing everything on this, everybody has on this Zoom call. So please, David may help me if he sees some questions. And, I don't even know if anybody else can talk other than me during this process. But if there is, send it by chat and we'll talk about it. Again, a lot of the things I'm going to talk about may kind of, hence the title hodgepodge, may be repeated and reiterated. Again, maybe that's okay because we've got a whole hour to wait. The good news about 11:15 is my hour is right before lunch, so you got a lot to look forward to get ready for the next panel of the judges that you really got to listen to, as opposed to Jay. Just kind of hopefully you'll get something out of what Jay has to say. First thing I want to talk about is the mediation. Mediation practice, both as a party, as a mediator, and I'm also going to talk about focus groups. And I think first and foremost, and I want to talk about pre-COVID, COVID, and yes, I don't know when COVID is going to end, but post-COVID. This process has been amazing to me. When we first started having the mandatory mediations, and that was a while ago, it seemed like I had a different kind of practice where I was trying a lot of rec cases and really didn't think about really trying to get a case resolved. And I still have some of those but not many. But the start of the mediations developed, and I became a mediator, and the process, I don't know, has really just been truly amazing. I now have the attitude that, and maybe again, it's because of my middle-agedness and my place in practicing law, is I think every case can be resolved. The difference to me now as a defense lawyer, and it's developed over the years, has been, before we did mandatory mediation, the goal was get the case ready for trial, and hopefully along the way, you could settle it the old-fashioned way with your other counsel. And that worked on some cases, and it worked pretty good. But obviously the mediations came in, and I didn't like the change. I didn't want to have to do mediations, but the change was just, very, very good for, I think, in all practice areas, at least that I've been around. and so today, my general attitude is, as I get a new case in, for the most part, I'm going to get the case ready first for mediation. And, a lot of cases, I'm going to call them kind of the run of the mill type cases. And, they could be, I do rec work, I do products liability cases, premises liability cases, dram shop cases, a hodgepodge of things. And so it obviously, depends on the case, the significance of the case. But for the most part, on the run of the mill cases, I really want to do a couple of things. And that's one, get the discovery, obviously meet with the client, do the written discovery. And I can't evaluate a case, whether it's run of the mill or significant, until I have the opportunity to actually meet and depose the plaintiff. And usually at that point in time, usually the plaintiff's counsel will depose the defendant. And most of the time, on most kind of run of the mill type cases, you can almost, I think, go right to mediation. You say, well, why can't you just go ahead and settle it? Well, these days, the mediation, it works, and you just kind of develop that way. I don't downplay the fact that you can settle it the old-fashioned way, but most of the time, those are the things that I look at. And if I can't get it settled at that mediation, it doesn't mean it won't settle later, but that's when you start doing those other things that you have to do to get ready for trial. You maybe get ready for a second mediation. That just again depends on the case. Now, pre-COVID, and COVID, I've talked to some lawyers this week and last week, kind of knowing that this was coming up, and for the most part, I get the same response that the cases are moving. They're not moving because there's, the jury trials aren't being had, but they are moving because parties are wanting to get their case settled. I don't have any actual statistics, but I really think that probably a high percentage of cases get resolved during this pandemic, at least in Jay's world and my little bubble, most of the time. I mean, I'm talking like maybe 85% of the time, and that kind of, again, kind of concerns me, because I want, I got to replace those cases with more cases in order to work and make a living. And so that there you have some more stress of a different kind. But to me, that is being, and I think it's because everybody just has that proper attitude. From a defense lawyer perspective, and again, my attitude now is a lot different than it was when I was, 35 or something, as opposed to, the wonderful age of 58. Because I've got to represent my client, usually the defendant, and that's my number one goal, obviously. But when I'm getting the adjuster ready, I really try, again, I really think, even as a defense lawyer, that every case can be settled. And I know that I've got to represent the client, number one, and number two, I've got to get the adjuster online, because it's the adjuster's money. And what I have been doing over the last several years is, when I send as the defense lawyer, see, I'm getting help as the defense lawyer from the plaintiff's lawyer, telling me, what they think the case is worth, their big strong points, and I'm trying to listen. And then when it gets time before, I got to, as the defense lawyer, before we go to the mediation, I've got to get the adjuster on board. And it's easier said than done, even to this day. And a lot of times, the more I think about it, sometimes I need the mediator's help to get the adjuster, to get the insurance company on board with what I've been saying. But, a lot of times you can't, you can't do that right at the mediation. You got to do it in advance. And for the longest time, I would send a pre-mediation report with just a settlement range, Jay's settlement range, which would, kind of look at trying to gauge it by what maybe the adjuster was lead me to believe. I want to, I want to get more work. I've changed that now. I give it really Jay's settlement range. I give a verdict range, which is hard to do right now because we hadn't had very many. I know there's been a few here and there, but we really haven't had any jury trials because of the pandemic. So I kind of gauge my verdict ranges on prior experiences beforehand. And usually that verdict range, the low end will kind of come up in that settlement range, and the high end will be, kind of protecting Jay as a lawyer to make sure that, if there is a really bad result, at least I've told him the possibilities of that. But what I have changed in the last probably the last 5 years, maybe even longer than that, is I give, even if I'm, I give Jay's prediction of the plaintiff's attorney's settlement range. Kind of I don't know if there is an art of evaluating cases, and this goes to my practice as a mediator as well, but I can evaluate, and again, this is from experience, not Jay, bragging about Jay, but I can pretty well, because I usually know the local plaintiff's attorneys, and they teach me a lot too. But I can usually have a pretty good idea from my discussions with the plaintiff's counsel and knowing their capabilities, knowing their experience, that I can pretty well guess their settlement range. And that helps me as a defense lawyer, where, even these days, and we've seen it, where you worry yourself about, maybe the insurance company gets mad at Jay and they, gosh knows, I don't want to get sued. I only have, 4, 5, 6 years left of trying to, practice. I don't want that to happen. But usually if I have that, plaintiff's settlement range between my high end on my settlement range and the low end of Jay's plaintiff's settlement range, there may be a crossover that gets the case settled. And my whole point there is the preparation of getting your adjuster ready for the mediation. Most of the cases that I have, and I'll talk about others where I'm having to get the client ready, but most of the cases I have, I am trying to get the adjuster ready to get the proper amount of authority to get the case settled. Back in the day, back when I, trying all these rec cases and, learning how to try cases, thank goodness, I would try everything. And today, I'm not scared about trying cases. In fact, I miss trying cases because of COVID, but because it's mediation settle everything. But, I still promote, and I will try a case in a heartbeat if need be. But I really want to emphasize I'm resolute, and I'm resolute in getting a fair, just, reasonable number. And if that fair, just, reasonable number doesn't satisfy the plaintiff, then we'll go try it. The important part of that is just getting the insurance company prepared. As a party, I'm always looking, the selection of a mediator. And, we all have our go-tos. And my general rule is to ask the plaintiff. I really want to go with somebody that plaintiff and the plaintiff's attorney is comfortable with. 9 times out of 10, I'm probably familiar with the mediator. We got a bunch of good mediators in the state of South Carolina, in Charleston, and gosh knows, my go-to mediator and one of my, is this helped me so much is John Tiller. And John Tiller has saved me in many a case. Then if I get to it, we'll get to it. That as a mediator, he has saved me from probably getting sued or at least a lot of bad dreams. So your selection of the mediator, is really important. And I talk to the other side about it too. I really do. Here's where to me, the format of the mediation has really changed. And in the beginning, I was really worried about, Zoom, the format, live, and I still, right now, I do some live and I do some mixed and do a lot on Zoom. But most of the time now during this pandemic, most insurance company representatives aren't allowed to travel, rightfully so. Some of them aren't even allowed to be on the screen. But my experience as a defense lawyer is that as long as the defense lawyer has done their job in preparing the adjuster, for the case, and gone through with them that pre-mediation report and gotten them ready, it doesn't matter. It really doesn't matter. Now, I get as a mediator that and I'll talk about that some in a minute, or as a plaintiff's lawyer, the plaintiff's lawyers really want that adjuster there so they can really, and as a mediator, I do too sometimes. But my experience, and I've talked to a lot of folks, I've done a lot of Zoom mediations, about the same amount of cases that I've, when we're doing them live, now doing them on Zoom with the adjuster not there, have resolved. I think I saw my friend Mark Bringardner's name flash up, and I know Mark and I've got a case where we haven't gotten it resolved. And that's because he's a doggone good lawyer and we got facts that we can't agree upon. But that's the few to me, even in this pandemic era. We've been able, because I don't find that insurance companies, the ones that I'm involved with at least, are holding the plaintiff hostage. Certainly they're pointing out to plaintiff's attorneys and to the individual plaintiff, that it's going to be, who knows when we're going to try a case. And then if it's a significant case, not only that, you got the appeal, but you had that beforehand. You also had, before COVID, you also had the unknown. Nobody, you can claim to know what a jury's going to do, but you really don't. That's the beauty of the jury system. And as a party, there's incentive to settle. The insurance company, guys, they want to get their pending down. They've got a job to do. They have incentive. There's still, the threat of, bad faith, all of that, the cost of trial, the delay. There's plenty of incentive, even during this pandemic, for the insurance company to settle. As a mediator, and I really do, I'm learning more and more as a mediator, and I've really, I can't even tell you, I became a certified mediator, I think back in 2007 or so, but over the last 10 years, I've really kind of promoted that as part of my practice. And I still have a full caseload, but I really like the part of my practice that I'll do as I get a little bit as I become less and less middle-aged and more older. There truly is an art to mediation. And the art is, as a mediator, I really want to get up on any case, and it doesn't matter, I want to get up with each counsel and talk to them about individually, about the strengths of their case. And usually when I have that call with plaintiff's counsel, when I have that call with defense counsel, I've got a pretty good idea of what I'm dealing with. And I know from the attitude of the attorneys, how hard is the mediation going to be? I can't overemphasize that as a mediator, I need plaintiff's counsel to get their client ready. They may have big expectations. That may be something that I have to help with on the individual side with the plaintiff. Defense counsel may have an insurance company that's just really hard-headed. And, I get those things and I know those things in advance and can start to work out generally what as a mediator I'm going to need to do. As a mediator, I don't have any power. It's all about the plaintiff and the defense having that good attitude that they're required to have because it is mandatory. And, coming in and really wanting to get the case settled. The whole mediation process, I think, even today in Zoom, and I'll tell individuals, not the attorneys, not the adjusters, not the people that are used to being in mediations, but the time that the plaintiff's attorney uses in advance to talk with his client, the time that I take or that the defense counsel takes to talk to their adjuster and to their client to get the case resolved. If it's an all-day mediation, that is so much better than going through a 3 or 4 day trial. And then even better than having to wait on that jury that you don't know what's going to happen and how long they deliberate. Those sort of things. And I know plaintiff's counsel and they want to get the case done like this. And I don't blame them. And sometimes I have that same feeling too. Why, I've been doing this 30 some odd years, why can't we just get to the, you got to remember, when I'm the insurance lawyer, I'm saying we got to check off the box. We got to go slow. When I'm telling the plaintiff, you've got to hear these numbers. And as off the wall as some of the numbers may seem, and not just exchanging numbers, you're talking about the facts of the case, maybe the law in the case. That's part of that process, and it works. One of the things I wanted to talk about, and then I thought I was going to run out of things to talk about, and I've been too long-winded. I've got this much more to talk about. We're not going to get to it. That's, old school Jay with his notes. Focus groups. And I'm talking really about, I've been here at Clausen and Stobbs, thank God, since 1988 as a lawyer, and even clerked here in 1987. So I've been here my entire career, and I've learned an awful lot from Sam Clausen. And Sam has done these focus groups both pre-COVID and now. And I hope to one day, in my mediation practice, I tell people in a kind of joking way, I'm getting closer and closer to being more like Sam as a mediator. I try to do that as a trial lawyer. And then now with these focus groups, these things are really, really effective. I talked to Sam yesterday. I don't get to see him very often because he's doing everything out of his house, being safe. But he's done 80 focus groups, and he's done a whole, he didn't have a number that he's done during the pandemic, but he'd indicated that they've all been, to his knowledge, very successful. They've had, out of that 80, 7 went to trial, and 5 of them were pretty well close in line to exactly kind of what the focus group had indicated. One out of that 7 that went to trial, I think 1 or 2 of them had some surprise rulings from the judge involved in the case. But I asked Sam, because I've participated in a focus group, and if you don't know what a focus group is, and I'll talk about, before COVID, we would literally get jurors from Charleston, potential jurors, and they'd come in and be live, and we'd have 2 different panels of 8 in our mediation conference room, and we would present, the case would be presented, and the leader, like Sam, would be the facilitator to facilitate kind of what the issues were going to be, and then there would be a presentation by plaintiff's counsel and defense counsel, and it was very effective. Most of the time, I think we've been retained through both. I was involved in one as the defense trucking lawyer, and this was pre-COVID, and so we did it live at the mediation center. And I learned so much by being just I made the defense pitch, but we were retained by the plaintiff's attorney because he really needed help in getting his client's expectations down, not up, down. And defense counsel was not involved in that case, and we presented to one panel an argument where the trucking company denied liability. They didn't seek punitives, but the trucking company denied it. In the other panel, they admitted simple negligence, but they sought punitives. And it was a significant injury case. And we did the presentation. We had the panel. We're watching with plaintiff's attorney the 2 different chairpersons start their deliberations, and I was shocked because I always thought it was only insurance companies that came up with multipliers, like 2 times the meds or 3 times the meds. I've always learned that it has nothing to do with anything, but I still sometimes use it. But each chairperson, even though liability was an issue, punitive damages was an issue, the first thing that each chairperson went, they weren't connected, they're in 2 separate rooms, was, I guess we got to start at 5 times the medicals. Kind of interesting. The long and the short of it, the end result of that was that both panels came back with about the same range, and I'm not going to tell you that, what the range was, but it helped plaintiff's counsel with his client, and it actually helped the defendant, the actual defendant who wasn't involved in it, get the case resolved for the amount that very close to what had been offered, maybe a little bit more, but it helped. During COVID, Sam selects his jury by social media. He can do these things from all over the state, heck, all over the country, that's where I've got to learn how to do all that kind of thing, but maybe I can get somebody to help me. But he has been he says he's been busy. He is, really utilizing that format. All right, I really want to talk some about everybody's favorite subject that is involved in personal injury. and that's Tiger River. Wow, in today's, for me, anytime I get a time demand letter, a Tiger River letter, I'm going to jump. And, what Tiger River stands for, bottom line is the insurer owes a duty of settling claims as settlement is the reasonable thing to do. And this, the role that I want to really talk about, this is where if you want to complicate a ham sandwich, this ham sandwich is complicated by the way we have the law, and I'm not arguing about it. It's just the way it is. And I've been doing it for a long time, where I'm retained by the insurance company to be the individual's lawyer through the insurance company, and then I'm not representing the insurance company, but the insurance company is responsible for, the money. And whenever I get that, time demand, I mean, I'm moving. That, to me, I want to make sure I get my answer filed. I want to respond to requests to admit, but I want to make sure I get, my ducks in a row with a time demand. What I do, and I'm not saying that this is right, this is just what I do. As soon as I get that time demand, I immediately notify my client, and at the same time, the adjuster. I then again meet with the client. Now, a lot of times you have run-of-the-mill cases, and when I initially meet with the client, I may talk about kind of the seriousness of a case. If it's a serious case, I certainly do. But most people that get sued, they just think insurance is going to pay it. They don't think that their personal assets are at risk. But when I get that time demand, I mean, I don't care if it's the run-of-the-mill case or cut off the arm case. Just, I'm going to meet with my client. I'm going to try and explain what's going on. I'm going to recommend to them that they need to go and get their own counsel. I tell them that, I'm your attorney, but I'm being paid by the insurance company. The insurance company's not doing anything wrong, but they may not settle this case within your policy limits. And there is a chance, sometimes more than just a chance, that this case could, bust the coverage. And I really want people to understand the importance of, I know as the insurance company defense lawyer what the case presents. I know the adversary. I know the issues. And I will direct my clients, because they don't have any clue who to go to. And they, what they really know is they got to pay somebody out of pocket to do something. And there may be a case where you got to send them to a real aggressive lawyer that's really going to just, stand up to the insurance company. It may be a case where, I need a personal lawyer to help me, because there's always a chance of an excess verdict. I never say never, where I need personal counsel, not to help me with the insurance company, but to help me with plaintiff's counsel. That selection is really important. The conflict I always had as a young lawyer, I was trying all these cases and really getting all these great results, mainly because it was, a bump case, and, I just show a picture and it just say, show me the money. And most of the time, I'd win. I got into this idea that, man, I can, and I get the time demands, and I wouldn't take them as seriously as I do now, mainly because I'm doing a lot different type of work. But I can't emphasize, and the work entailed, and From a mediator standpoint, personal counsel is involved. You know, I'm glad of that. If I didn't have personal counsel involved in a recent dram shop case that I did as a mediator, you know, I wouldn't have gotten the insurance company to pay the kind of money that they did to get the case settled. So, you know, the long and the short of it is, you know, when I do the things I do when I get that demand letter, notify both my client and the adjuster, meet with the client, get them to personal counsel, tell the insurance company that they have to respond in writing themselves on, you know, whatever insurance company letterhead, not J. And then we go, you know, and there's some, you know, you get each insurance defense lawyer. All defense lawyers that I know are really, really good. They know the impact of this, and you know, it is a scary event for the client when they're looking at their personal assets. All right, guys, I got to about two of my topics on my list. I got 15 minutes. I was thinking 12 o'clock, so good. Okay, I was rushing there. David, I still got 15 minutes, so I'm good.
Yeah, just under.
All right. In that line, I want to, you know, over the years, you know, I've had moments of, you know, just, you know, of where, you know, I'm amazed that I got this verdict, or wow, I got popped. But I'm going to share with y'all, and it has to do with the role of personal counsel in a bad case. And I can't, you know, Ronnie Crosby is one of the nicest guys you'll ever meet. He is one of the best doggone tire lawyers in the world. You know, I learned a lot from him on this particular case because he was plaintiff's counsel. And I say that because I really do learn from most of, you know, I've got friends on both sides of the ball, offense and defense. But I've learned so much from really good plaintiff's lawyers. It's just, you know, just amazing. And in this case was an awful case. It was a tire blowout case. And it had the tire manufacturer involved in the case. But let me tell you, it was the tire blew. I didn't have the manufacturer. I had the, I'm going to call it the Hay Tire of Florence. It wasn't Hay Tire, and I'm not going to say the name, but that's who I was representing. But at any rate, this is what I was dealing with. The driver, the dad, was ejected, died in the arms of the front seat son. The back seat, there was two back seat sons. One was injured so badly they thought he was paralyzed. He made a really great recovery, but still was significantly injured. And the other son somehow was in the back seat that was okay. And, you know, so I'm dealing with something like that, a horrible set of circumstances. We have a very good defense, at least I think so. And as I went through the process of, you know, learning more and more about the tires and the tire cases and getting educated by Ronnie and getting some assistance from other friends and other defense lawyers, I knew I was, you know, really up the creek. And I was also up the creek, you know, with the carrier. Carrier was not a carrier that I was normally dealing with, you know, and so it was, you know, and there we go again. Of course, Ronnie wants to use Tiller. Now, Tiller saved not at the mediation, but during the course of the post-mediation factors. The moment of one of my moments of my career was this case, and nobody really knows about it. Dealing with a time demand. I got a really good, strong lawyer for personal counsel for the Hay Tire of Florence. And there's nothing like sitting through a mediation where, you know, there's that wedge between my client and the insurance company happens. And that happened here. And, you know, the long and the short of it, Ronnie would not come down very much off. There were only $3 million in coverage, but he would not come hardly off of that at all. And we mediated it and mediated it. I begged and begged. Tiller did a great job. We did not get the case settled. And Ronnie looked at me and just says, Jay, you have until, and this was 3 years ago, I guess, you have until 4 o'clock on, I don't know, I'm gonna pick a date, December 18th, you know, for your carrier to do right to their insured. The carrier was insistent upon offering the money, and it was substantial, but it wasn't close to the 3. And in the backdrop, I'm dealing with my client. My number one person is my client, my client's personal counsel. And my client was actually just kind of one of the nicest folks, you know, in the world. And by about, and I'd had a lot of conferences with 7 or 8 people at this insurance company, and they weren't going to budge. And about 3:30 before the deadline, my client just calls me along with their counsel and just says, Jay, just tell the attorney we're going to settle this case. They were going to cut a check, a significant check out of their own pocket. I'm talking, you know, over $500,000 that they were going to cut, and they were going to go later after the insurance company. And I said, well, I'm going to utilize that with your permission. And they said, do whatever you need to do. I get back on the phone, start talking with the carrier. The long and the short of it is the carrier ended up paying the difference. They didn't pay their full amount, but they paid the amount right around the area of where Ronnie had, you know, I'll admit, rightfully had drawn the line. And there's not a better feeling in the world. Defense verdict, you know, man, that's a great feeling. Hunter Renfro catching that pass to win the national championship, man, that's a great feeling. But to have saved my client that kind of money, it doesn't get any much better than that as an insurance defense lawyer, middle-aged, young, or old. And that was a moment that I will always remember. And that was some good lawyering from Ronnie, from John Tiller, from Kathy Elmore up in Florence, and yeah, from Jay. You know, there's not much of a better feeling than saving your client that kind of money. And even if he would have paid and cut that check, God, it would have been, you know, another bad faith kind of lawsuit against the insurance company. I'm going to tell you about another case that was just recent, and it dealt with this doggone, and I say doggone, it's a very well written and very well thought out decision, the Poole decision that, you know, talks about, you know, for those of you that are on here, the question posed to the court was whether South Carolina law requires that punitive damages be apportioned pro rata between those for bodily injury and property damage under an automobile insurance policy. We answer that question, no. That decision, and I'm not arguing with it because I'm not one of the ones arguing, we had to deal with, and we continue to deal with on a pretty much an everyday basis, particularly for you know, the 2550 policies and what that has created, which is, you know, again, the law, and I have to deal with it. But the case I wanted to tell y'all about was a one-car accident where I had the young driver. There was awful case. I think the personal counsel is on this phone call, and he did a great job. My client was the at-fault driver, and he lost control going around a curb, ran into a tree, pretty significant. The plaintiff in the back seat broke his left clavicle, had to have surgery. And, you know, I was defending through an insurance company through the primary liability, which had substantial coverage, 100,000, had 100,000 property damage. And also I was defending the UIM carrier, which happened to be the same company, you know, and all through properly, you know, gotten everybody's okay to do it all the way around. And the issue in that case, you know, the actual damages were about 60,000. Young guy, 17, really nice young man. All the folks in the car were nice. There was an issue presented by the plaintiff, who was the back seat, didn't really know too well the driver and the front seat friend passenger, even though they were all going to Cookout to go get something to eat, and they were claiming that the young driver was drifting. In other words, trying to, you know, make his back tires do a fishtail when it was raining around a bad curve. So we had punitive as an issue, and we had actual damages as an issue. You know, in this case, we mediated it. The case is still going on as far as the underinsured part of the case. But the real, you know, and it was a really good plaintiff's lawyer, and he was demanding at mediation both the 100 BI and the 100 PD. Of course, I was arguing that my client was just being 16, that there wasn't any drifting, that he lost control, and it was a simple negligence case. That PD issue, the young man in the back seat, it wasn't his car. The property damage he had, he tore his pants during the accident. So that part of it was satisfied, and certainly punitives were an issue. And it created, you know, an all-day mediation to get the right number, you know, and part of that was, you know, plaintiff's counsel did not want to be, and he did a really good job. He got the 100 BI, and then he got a portion of the property damage. He did not want the insurance company, which was the same insurance company for the underinsured part, to claim the 100 PD as a set-off. And because the insurance company knew that if they didn't pay the PD and agree that the only set-off that he was entitled to was the 100 BI, that he was going to subject my client to potential excess verdict. Now, in this case, the young man, the family, I had personal counsel there, and he did such a good job helping me with the company, with the carrier, and also helping the mediator with the very good plaintiff's lawyer, that all of a sudden my insurance company at the end of that mediation, even though we didn't settle it outright, told the personal counsel, send me a bill. And that insurance company paid personal counsel, who I could not have gotten that case resolved. And I think he's on this. So I'll just thank him. Thank you, Bobby Phipps. I won't mention the other names involved, but did a great job with helping me to help my client, his friend and his client, the injured party, and the insurance company to get a tough case at least resolved and protect the client. Still have a lot to talk about. I was worried about running out of things and not being able to talk enough. I hope everybody got something out of that. I don't know if we have any questions or not. But David, thank you so much for the opportunity to give Jay's hodgepodge and Jay's personal injury world here in my bubble on Daniel Island.
Well, Jay, thank you very much. I'm checking to see if we've got any questions coming in, but we have not had any yet. And I think with this being the break for lunch, I suspect that you may not have anybody that is concerned about a question at the moment. But I do want to thank you very much. That was a great presentation. Unless we get a question in the next moment, we will break for lunch until a little bit before 1:15. I'll give a couple comments and then we'll get started with the judges panel. So thank you, and I hope everybody has a good lunch.